All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Mr. Court Officer, please call the case.
Good morning, Your Honors. This is the file number KSC-BC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi. Thank you, Your Honors.
Good morning, everyone. Today we will begin hearing the closing statements. Now, first of all, I'll ask all the parties and participants to indicate who is present for today's hearing, beginning with the prosecutor's office.
Good morning, Your Honors. Today, the SPO is represented by Nathan Quick, Claire Lawson, Mr. Alan Teeger, James Potch, and Matthew Holling, and I'm Specialist Prosecutor Kim West.
Thank you, Madam Prosecutor. Victims' Counsel.
Good morning, Your Honours. I'm Simon Laws, representing the victims in this case.
Thank you, Mr. Laws. Counsel for Mr. Thaçi.
Good morning, Your Honors. I'm Luka Mishetic, counsel for Mr. Thaçi. To my right is my co-counsel, Ms. Nina Tavakoli, our legal associates, Ms. Valenza Limani and Mr. Mate Pustai, and behind me is Ms. Bonnie Johnson and Mr. Liram Grayevtsi. Thank you.
Good morning, Your Honours. Rodney Dixon for Mr. Veseli, assisted by my co-counsel, Ms. Rowan, Ms. O'Reilly, and legal assistants, Mr. Kaon and Ms. Anna Hermitage. Thank you.
Thank you, Mr. Dixon. Mr. Roberts for the Salimi defense.
Good morning, Your Honour. And Jeff Roberts on behalf of Recep Salimi, together with, to my right, Mr. Eric Tully, Mr. Chad Mayer, co-counsels, and legal consultant, Ms. Fortuna Sheremetti, and behind me, Ms. Riva Jeshai and Mr. Christian Vale, our legal associates. Thank you.
Thank you, Mr. Roberts. Counsel for Mr. Krasniqi.
Morning, Your Honours. Venkateshwari Alagendra for Mr. Jakub Krasniqi, and appearing together with Mr. Aidan Ellis and Victor Bayesu, co-counsels, Mr. Mentor Bitiri and Mr. Jacopo Ricci, legal associates, and Mr. Bilal Sharifi. Thank you.
Thank you. From the registry, anybody?
Good morning, Your Honours. Fidel Madonlan, the registrar.
Thank you, Madam Registry. For the record, I note that all the accused are present in the courtroom today. So before we begin with the closing arguments, closing statements, the photographer has asked permission to take a few pictures. You may go ahead. Today we will begin hearing the closing statements in this case. We will follow the agenda set out in the panel's order on the closing statements, which is filing F03639. As a reminder, today's hearing is scheduled to conclude at 16:45, and breaks are scheduled for half an hour at 10:30, resuming at 11, 1.5 hours for lunch, beginning at 1300 and resuming at 14:30, 15 minutes, a 15-minute break at 15:30, resuming at 15:45. Before we start with the closing statements, there are some preliminary matters the panel wishes to address. First, on November 6, 2025, the panel issued Order F03565, in which it ordered the parties and participants to provide submissions on the feasibility of holding reparation proceedings after the conclusion of the closing arguments and before the issuance of the trial judgment. Having considered the submissions of the parties and participants, the panel confirms that it maintains its position set out in its order of December 4, 2024, specifically that any request for reparations should be filed by victims' counsel after the judgment in this case and after any verdicts on the counts are determined. Second, the panel recalls that the SPO, the Krasniqi defense, and the Salimi defense respectively requested that members of their teams be granted rights of audience for the purpose of participating in parts of the closing statements. Specifically, the panel recalls that the SPO requested that Ms. Lawson be granted the right of audience. The Krasniqi defense requested that Mr. Bachiri and Mr. Ricci be granted rights of audience. And three, the Salimi defense requested that Ms. Sheremetti be granted right of audience. Since the parties and participants have all confirmed that they have no objection to the requests, the panel grants these individual rights of audience for the purpose of participating in these closing statements. Lastly, since the closing statements are being interpreted, the panel reminds the parties and participants to speak at a slow pace to allow the interpreters to catch up, and to be especially mindful when you are reading that one has a tendency to read faster than you would speak normally. So be conscious of that and try to control the speed of your speaking. This concludes the remarks from the panel. We will now start with the closing statements of the Specialist Prosecutor's Office. You have been allocated 8 hours, and you may proceed.
Good morning, Your Honors, Madam Registrar, and everyone in and around the courtroom. It is a privilege to address you here at the closings of the largest case to have successfully progressed through this distinguished institution. With 5+ years behind us, the Kosovo Specialist Chambers has become a regular and conventional court, conducting hearings and trials and representing to the world that international justice and the rule of law is routine within these four walls. Furthermore, we have also demonstrated that the climate of intimidation can be managed in a manner which ensures that the truth is still heard. In short, we have become a successfully functioning court in a relatively short period of time. The thanks for that, of course, goes to the judiciary, the KSC, and SPO staff, the defense bar sitting before me today, and victims counsel, all with decades of legal experience and all of whom have practiced with an admired professionalism and expertise. Any young lawyer who has stood in the well of this courtroom will have witnessed it and learned from it. But I save my eternal gratitude for those who deserve it the most, for those who have personally taken it upon their own shoulders to ensure that the rule of law is delivered to the people of Kosovo. That is, those victims and witnesses who have come to this court to give their testimony. And despite fears, threats, and stigma being forced upon witnesses and their families by a limited but vocal group in Kosovo, these witnesses have so yearned for the truth to come out that they nonetheless chose to cooperate with my office and give evidence to this court. all in an effort to assist in creating a credible and reliable record of the events from 1998 and 1999, where over 100 people were killed and hundreds more abused in and around 50-plus KLA detention camps. This case is about the four accused goal to gain and exercise control over all of Kosovo. But this determination for power had something standing in the way. That is, people who were deemed to be opponents, those who were perceived to be collaborating with Serbian forces or officials or state institutions, or not supporting the aims or means of the KLA and later the PGOK. This often included people associated with the LDK and persons of Serb and Roma ethnicities. And in order to achieve their goal, the accused committed crimes against their perceived opponents to take control over Kosovo. Your Honors heard the testimony of the prosecution witnesses called in this case. They included many KLA witnesses, other Kosovars from all different walks of life, numerous victims of varying ethnicities and their family members, and some internationals who were present in Kosovo in 1998 and 99. The evidence of all the witnesses, as well as the documentary, video, and forensic evidence presented, reveals that these crimes were committed and that the accused bear legal responsibility for them. The court also heard live evidence from 7 defense witnesses, all internationals. Each was involved in discrete efforts to bring peace and administration to Kosovo, and they should be applauded for their efforts. But whether their involvement in this case and their limited observations are valuable for the purposes of this court is an entirely different matter. For the most part, the 7 international witnesses parachuted into a situation with little background knowledge of the players involved, did not speak the language, interacted face-to-face with key players only a handful of times, hardly if ever saw any KLA rules, regulations, orders, or communiques, and were not familiar with the KLA structure. For the context of their very specific jobs, this scant layer of information may have been sufficient, but it is woefully inadequate for accurate fact-finding by this court. Your Honor, today and through our presentations, we will show a number of slides, and we request control of the screen. I'll also note that all the slides used during the SBO presentation are for public broadcast unless the speaker specifically indicates otherwise. This dearth of information was most aptly described by a defense witness himself, the UMIC deputy, who in offering to explain to the court the role of a diplomat and how they arrive at their judgments, candidly testified to the following. Quote, "It is the duty, the role of the court to, as much as possible, gather empirical evidence. So it may come as a bit confusing that that's not at all how diplomats, peacemakers proceed and how they reach their conclusions. Diplomats know from the outset they will almost never know the full story. They have to reach judgments, make strategies, and advise their governments on the basis of necessarily incomplete information," end quote. And this incomplete information does undoubtedly lack exactly what this court must prioritize: empirical evidence. This handicap was not only true for the UMIC deputy who conceded it in his testimony, but it was also equally true for the rest of the international defense witnesses. Unfortunately, this trial did not escape the long-standing and pervasive climate of intimidation that had been forecasted from the start. To the extent the court must consider it to make a fair assessment of witness reliability, it should. Indeed, the evidence before you suggests that at least some of these efforts took place right here in The Hague. Still, the court has before it overwhelming evidence that, for example, the accused were key members of the KLA General Staff well before November 1998, and evidence that the zone commanders took orders from the accused and not the other way around. Clear efforts made to change, dilute, or otherwise influence certain testimony, in particular to the accused Hashim Thaçi's benefit, have been uncovered. A few significant and representative examples of those efforts are now part of the record, and any attempts to cynically distort accurate fact-finding by this court must entirely and utterly fail when the evidence is assessed as a whole. Despite these efforts, many witnesses have been undeterred from ensuring that a credible record of the events is created. And this speaks not only to their courage, but also to the strength of this court and the transparency of the process. This court has presented an opportunity for the rule of law to take center stage and for the truth to come out. One such witness, who lost her son and husband, never recovered their bodies, testified. W00072 spoke of the importance of knowing and valuing the truth in the words that only a mother and wife who had suffered an unspeakable tragedy could voice. She said, quote, "I will go to the end of the world just to reach the truth. And as long as I can, I will not give up until I learn the truth and just the truth. And I will continue to go wherever I'm invited to come. I won't stop. I will die with my pain and my wound on my heart. It's almost as if I have seen my son and my husband again." Unquote. It is important to note that after the charged crimes, this witness left the country and never returned to her family home in Kosovo. Many of our Kosovo Albanian witnesses did not have that option, making their willingness to testify here more complicated. Yet some risked it to describe to you their sadness and unresolved feelings of loss at not knowing what truly happened to their family members, despite having asked repeatedly. W04811 explained, quote, 25 years with no answer. And we don't know, and that is what kills you the most, unquote. W04368 gave evidence that after one of his relatives was taken away by the KLA for questioning, the family never saw the relative again. The family repeatedly asked the KLA for information, but were denied any answers. He testified, quote, "This has been very difficult for me and for all my family. I don't know. We don't know why they took him away, for what reason. When you take somebody from his or her own home without a reason, there's no explanation for that," unquote. To this day, this family continues to suffer in the absence of closure. The facts of this case and the applicable law support a lengthy term of imprisonment for each of the accused. A full explanation of the relevant factual and legal considerations has been laid out in the prosecution's final trial brief, and I will not repeat all the factors here. While my colleagues will shortly highlight certain evidence in their presentations and address certain defense arguments, we rest on our brief, which more comprehensively outlines our case. However, it is important that the SBO's position is well understood. A conviction and sentence are not sought against the General Staff, nor against the KLA. Equally, no conviction is sought and no sentence can be imposed on the sole basis of being a member of the General Staff or of the KLA. Rather, the SPO has requested convictions on all 10 counts and the imposition of a single sentence of 45 years based on the individual contributions to the crimes, which are charged in the indictment, made by each of Hashim Thaçi, Kadri Vaseli, Recep Salimi, and Jakub Krasniqi. These crimes are war crimes and crimes against humanity and are grave in nature. And the gravity of the charges has not diminished with the passage of time. For the remainder of the prosecution's time, my colleagues will discuss the responsibility of the accused for the charged crimes. First, Mr. Tiger and Ms. Lawson will discuss the accused's plan to gain and exercise control over all of Kosovo and the criminal steps they took to eliminate opponents and achieve their goal. Mr. Poch will then summarize the pattern of crimes, including persecution, cruel treatment, arbitrary detention, torture, murder, and enforced disappearances, which occurred under the accused's authority and pursuant to their common criminal purpose. Mr. Quick will then discuss the structure and functioning of the General Staff and the KLA during the indictment period. Mr. Quick will also speak about the PGOK's creation and how it provided the accused with an additional parallel vehicle by which to execute and accomplish their common criminal plan. Finally, Mr. Howling will discuss the remaining elements for individual criminal responsibility. Thank you, Your Honors.
Of the common purpose to gain control by means that include the unlawful intimidation and mistreatment of those deemed to be opponents in an extraordinarily vast array of evidence. Communiques, public declarations, regulations, orders, intelligence and military police reports, notebooks, journals, meetings, inspections, appointments and promotions, efforts to deflect, deny, and justify crimes, the accused participation in crimes, and of course, witness evidence. From the beginning of the indictment period to the end, throughout different phases of the conflict, whether the common purpose was being publicly proclaimed or being modulated in response to concerns about the international community, the targeting of collaborators continued. I will address 1998, and Ms. Lawson will then address events of 1999. But to fully understand what happened from March 98 onwards, it's helpful to know a bit about who the accused were at that time and how they got there. Because unlike many who had joined the KLA during this period, the accused were not galvanized by the killings of the Yashari family to volunteer. Instead, they were the pioneers of the KLA who had led it to that point. As another core member of the KLA General Staff said, Hashim Thaçi, Kadri Vaseli, and Recep Salimi were among the few protagonists who were part of a, quote, common structure and who, quote, started the war and finished it. Jakub Krasniqi, a respected public figure, joined that structure later, but would play a comparably important role. It began, as Jakub Krasniqi explained in his first appearance as KLA spokesperson, with the LPK. And this is subtitled, so there is no need for translation. The LPK is the political force, as Mr. Krasniqi noted, that deserves uncontested credit for founding the Kosovo Liberation Army. As Azim Sula said in P. 1875, the KLA could be regarded as a creation of the military wing of the LPK. Levizia Popolare e Kosovos, or LPK, was an underground political group which considered that pan-Albanian liberation would not happen without armed conflict. And in the early 90s, it tasked a handful of members to form its military wing. And as Ilaz Kadoli noted in P12, quote, to start armed attacks against Serbian army, police, and collaborators with the Serbian occupier in Kosovo. Hashim Thaçi and Kadri Veseli, friends since their early student days, were key players in that process at the forefront of the KLA from the beginning. That's P 4216. As Mr. Thaçi explained in his SPO interview, echoing what he had also told the ICTY, quote, when we started our activity in 1992-93, we were a small group of people. We were patriots. We were from Drenica. I was one of the people that established it, one of the founders, and this is well known. And similarly, Mr. Veseli explained in his SPRK testimony, quote, I was a member of the KLA from the very beginning. I am actually one of the founders. I was a member of the KLA main HQ since the beginning. Mr. Thaçi had a big role from the start, leading organized activities, and Mr. Veseli recalled how during the period until 1994, he and Mr. Thaçi would go back and forth to Albania. In 1994, they left for Switzerland. And from then until March 98, they would come to Kosovo every 3 to 4 months, spending 2 to 4 weeks at a time. That's P 739.4. Thaçi and Veseli had many important duties during this time, maintaining contacts, organizing, and bringing in arms, including 7 of the 12 RPGs used in the synchronized attack on 12 Serbian police stations in September 1997. That's P 4200 and P 1883. Mr. Thaçi earned a reputation as one who bridged the gap between fighters in Kosovo and planners in exile. As a biographer of the KLA noted after consulting extensively with Mr. Thaçi and other leaders. As Mr. Vasselli said in P 4216, Thaçi was someone who not only led politically, but, quote, put himself in danger, and, quote, is a fighter and at the same time a political leader. Recep Salimi, another founding member of the General Staff, was known for his close connection to Adam Yashari and his role as one of the earliest participants and organizers in battle, including his organization of and participation in the synchronized attacks in September 97. And as Mr. Salimi himself observed in P 761.4, someone who enjoyed widespread respect and credibility among the fighters. This background and stature was reflected in the description by one well-placed witness of Thaçi, Vasselli, and Salimi as, quote, the strong men of the KLA. That's P 1097.9. And why Ramush Haradnai included Hashim Thaçi and Kadri Vasselli, Recep Salimi, among his 4 proposed candidates for commander of the KLA. A leader of the KLA, as one witness made clear, was one at the inception or core of the idea of war, and who had established or formed the KLA more than anyone else. That's P 1136.4. As mentioned, Jakub Krasniqi also enjoyed widespread respect, in particular as a former political prisoner. Although he had maintained a legal profile with the LDK during the 90s, he had made contact with Adam Yashari in 1991, had been involved with the KLA since 1993, that's P 186, and has explained that he joined the General Staff no later than the beginning of 1997, that's P 794, thus bringing the accused together. And throughout, their work was collective in nature. As Kadri Vasselli said, quote, we have had our responsibilities during the entire time in the period 92 through 98. We had our general staff and the operational staff of the UCK. We did not have separate duties, but all did whatever we could. Recep Salimi also underscored in his SPO interview that decisions were made collectively. And Sokol Bashoda noted in his ICTY interview that collective decision-making applied to decisions about collaborators. The period from the mid-90s to March 1998 was marked by increased organization and armed attacks, as well as determined efforts to ensure that the world knew what the KLA was doing and to magnify the intimidating impact of armed attacks to the full. General or central staff communiques over the next 3 to 4 years disseminated a consistent message. The General Staff sought the independence of Kosovo. It would continue until final victory. Political parties who considered signing for autonomy would be, quote, punished as a traitor. It was only the KLA General Staff which had the right to govern and lead in Kosovo, and those now on, quote, the other side must support their struggle or receive their, quote, deserved punishment. The occupiers' collaborators would be dealt with mercilessly, and armed units were carrying out attacks on those collaborators. And I refer your honors, for example, to P269, ET.1, 2, 5, 6, 8, and 9, 15, P274, P277, and P279, as well as P4290. Now, the communiques revealed that these particular attack collaborators included Serbs labeled as colonizers, a member of the Serbian Socialist Party who had made a commemorative speech at the funeral of someone executed by KLA units, the rector of the Serb University in Pristina and his personal driver, persons allegedly known for open collaboration with the occupiers' bodies or for other unspecified anti-nationalist activity. These targets were in line with the extremely broad scope of collaboration as communicated by the General Staff. For example, those who, quote, blindly serve the foreign enslavers, or, quote, undermine and jeopardize the fate of our liberation war. That's P269.15. There are instances in which Mr. Krasniqi or others assert that collaborators are people who serve the police and the soldiers. Now, first, even this false limitation cannot serve to justify the crimes, as you'll hear later from Mr. Potch. But second, the evidence, as always, must be assessed as a whole, and there are many more communications and statements that make clear that collaborators included all who were deemed to serve or bow to the occupier. Mr. Krasniqi, for example, made clear in ICTY testimony, that's P794, that collaborators were, quote, the stooges of the Serb regime who served this violent regime, that they were, quote, numerous in the economic, cultural, and political spheres, as well as the security spheres, and included all those who had done harm to the political and military actions of the KLA. He noted also that the Serbian regime apparatus couldn't function in Kosovo only through its police and soldiers, and explained that, quote, this apparatus extended its tentacles to all the pores of public administration. The defense has attempted to dismiss the communiques as, quote, propaganda, a word they use as a euphemism for untruthful. That claim is belied by the evidence. First, you can find multiple examples of such corroboration in paragraphs 1473 through 1480 of our final brief. And while the communiques may have exaggerated the extent of KLA success or downplayed difficulties, Mr. Krasniqi testified that the basic facts were accurate and in fact validated by other media reports. That's at P800. Indeed, Mr. Krasniqi specifically confirmed in P794 the substance of a number of communiques and could not think of a single communique he considered not to have actually been issued by the General Staff. As Mr. Krasniqi agreed when testifying before the ICTY at P795, page 3420, propaganda is, quote, an organizational program of publicity or selected information to propagate a doctrine or practice. And that is exactly what the communiques did. Further corroboration of the communiques is found in the ICTY evidence of Sokol Bashota at P 1870.3. Asked the simple question how collaborators were dealt with, he explained that, quote, by a decision of the General Staff, measures were taken against them, unquote, which were, quote, intended to convey the message that no one should behave this way again. And he continued, quote, and the General Staff in the communiques would announce that other people who behaved in the same way should take care not to do so. Collaborators, he explained, were given a warning, and only if they failed to stop, punitive measures were taken. And asked what those punitive measures were, quote, In most cases, decisions were made to kill them, unquote. And you can see an example of precisely that in Communique 28. Quote, the KLA Central staff took the decision to have them executed after they had been warned earlier to quit their collaboration with occupiers and in line with KLA Central staff decision published in Communique number 27. One of the victims was an MP of the Socialist Party of Serbia. Zara Ikasovis, an LPK organ, concluded that his liquidation indicated that, quote, the Albanian people is determined on its road to settle the scores with all those that obstruct the sun of freedom, unquote. And in an example of both the breadth of the definition and the effort to maximize the intimidating impact, Communique number 28 also declared that these executions should serve as a warning to all collaborators and traitors, quote, especially those who, under the pretext of being pressured by certain international power centers, are likely to make deals to sign agreements with occupiers contrary to national interests. Another example is Communique number 29. Quote, the first assassination was carried out on 13 January of this year, where our guerrilla units executed the collaborator of the Serbian police, Fazli Hassani from Brabanic Mitrovica. This decision was taken following a long review of his anti-nationalist activities. And again, a broad warning to a wide audience of potential collaborators. Quote, this is the last time we are appealing to the occupiers' collaborators to give up their shameless path. Otherwise, the people's revengeful arm shall strike them mercilessly anywhere and everywhere. The defense has emphasized that Bashota told this court that he was only speaking hypothetically, only musing. Any fair reading of his evidence before the ICTY, however, reveals that this is simply not the case. First, it is crystal clear that he is responding to the question that was asked by simply relating what happened for much of his answer. And even after the moment to which the defense points as evidence of hypothesizing, Bashota stated flatly about collaborators who were warned, quote, and some of these people respected the warnings and some no, unquote. And that's at page 19 of P1870.3. The defense also asserted, that's the Salimi brief, paragraph 594, that Bashota recanted his evidence concerning the collective decision-making of the general staff in relation to collaborators. In fact, he confirmed it. Despite unmistakable efforts to water down the level of specificity in detail as the import of his evidence became more apparent, Bashota nevertheless acknowledged that what he euphemistically characterized as appeals to not collaborate with the enemy were indeed collective decisions expressed through communiques. That's T22, 986 through 87. And he also confirmed that the communiques were widely known to public opinion as well as to KLA soldiers. Shortly after he became official spokesperson, Jakub Krasniqi said in an interview that he confirmed to the ICTY, confirmed its accuracy, quote, collaborators are warned that we will kill them if they continue to follow the wrong path. And he followed it up with the transparently false reassurance, however, as an army we observe all international rules of warfare. That's P809. Indeed, at its most important moments, the General Staff corroborated the targeting of collaborators over and again. For example, when the KLA came out publicly in November 1997, Recep Salimi emphasized to the crowd what the KLA had been doing, carrying out liberation actions against the occupiers, quote, as well as their Albanian-speaking collaborationists. He also noted that those who take pacifist positions, quote, denigrate our holy war. That's P. 1878. And when members of the General Staff made their first televised appearance in early March 1998, they made clear that they would not accept autonomy, issued a thinly veiled warning to the Kosovar Albanian government to hand over the funds it had gathered or face full responsibility, and noted that all the actions of the KLA had been directed against the Serb occupier, quote, and against the collaborators of the oppressor. That's P. 4217. Now, this was the beginning of March, when the accused were at the very core of the still small group that had pledged itself to the liberation of Kosovo by armed force against the Serbian police, army, and collaborators and traitors. But the beginning of March was also infamously marked by the attack on the Yashari compound and the killing of Adam Yashari and his family, an event that sparked what all parties agree was the beginning of the explosive expansion of the KLA from its guerrilla unit's origins. Now, you'll hear from Mr. Quick in much more detail about the creation and consolidation of units by the General Staff during this time. For now, I'll simply offer a general picture. The General Staff, which for years assured potential followers and the public that they would not stop, even should the conflict grow bloodier and wider, acted immediately. As detailed in our final brief at paragraphs 25 through 27, Hashim Thaçi, Kadri Veseli, and a large group of LPK and trusted activists entered Kosovo, where those activists took up positions of leadership, organizing existing units and forming new ones from the flood of volunteers who now wanted to join an army to liberate Kosovo, proud to take an oath to be a loyal soldier and to be punished by death if they violated that oath. At the same time, the General Staff strengthened and formalized existing relationships in such places as Dukagini and Lap, and recruited and vetted professional soldiers to help in training and building the KLA. As Jakub Krasniqi put it in P796, the KLA began to expand from a guerrilla army, and it was the General Staff that, quote, had the responsibility to organize this army. This was indeed a hands-on period for the General Staff. As Bislam Zarapi noted in P605, before the arrival of the military professionals, the KLA General Staff had control of their units, but, quote, the way in which until then the staff exercised control had been a great burden to it, unquote. Now, that reflected how active, engaged, and busy the accused and other members of the General Staff were. Zarapi himself had to wait around in Albania for quite some time, even after he was vetted and cleared for Mr. Thaçi to arrive from Kosovo and take him in. And you can see more reflections of that in P1265. Now, this is not for public broadcast. This is a notebook seized from Recep Salimi. For various reasons, including the nature of third-party references to him and the difference in handwriting from notes assessed to be written by him, we don't assess this particular notebook to have been written by Mr. Salimi. Now, P1265 records various events from the 12th of May in the vicinity of Umira and Likots. For example, the establishment of the first military police station in Likots on 18 March, or a request that a military police unit be formed in Umira, or 2 posts of Suhareka converging to the base Cheliku, or Nui Batici asking to report on aid supply and family life. And you can find those at 65, 42, 44, and 45. And the notebook reflects throughout Mr. Salimi's presence, importance, and involvement, including at page 6541, motivation came for training, meeting with 10. At page 6542, motive, meeting with 10. 6566, motive for coming to consult with 10 about arms supply and organization of the post. And also, I talked with them in Chabich, and they advised me to talk with 10. Or at page 6607, request to 10, a sniper has been promised to Hikuri Imasor. He is requesting that the promise come to fruition. And numerous other references scattered throughout the notebook. And just one more reflection of what Mr. Zarapi was referring to, bearing in mind that you'll hear much more on this subject from Mr. Quick. Think of significant battles or events during this period. So, in the aftermath of the Glojan attack in March, Hashim Thaçi and Kadri Vaseli were there. That's paragraph 672 of the final brief. Daychan in May, Kadri Vaseli and Hashim Thaçi were there. P 1355.1. Balachavach Mine in June, Hashim Thaçi and Kadri Vaseli were there. P 1273. Rahavets in July, Hashim Thaçi, Kadri Vaseli, and Recep Salimi were there. P 1355.2. Lapushnik Gorge, Hashim Thaçi and Kadri Vaseli were there. P 189.7, page 70. So in this burdensome way, to borrow Mr. Zarapi's phrase, the General Staff was building an army, including rapidly formed specialized units for special tasks, military police, intelligence, special units. And as we've discussed, the General Staff had for years been assuring the region, and particularly its potential followers in its communications, that collaborators would be tracked down and dealt with mercilessly. And that is exactly what happened. Consider again P 1265, the notebook seized from Mr. Salimi that reflected his presence and involvement. That notebook also reveals the focus on collaborators and suspects throughout, including for such things as having frequent contacts with a brother-in-law who is a Serbian policeman, or for meeting with 3 fellow villagers who were Serbs, or for insulting the KLA, referring to them as monkeys or thugs, or for having intimate relations with a police officer and a child with him, or for the recent acquisition of a phone. You can find those at pages 6591, 92, 6605, and 6609. Indeed, contemporaneous notebooks and notes are replete with reflections of the targeting of collaborators by police, intelligence, and special units. And just to name a few examples, P75, P74, P2455, P2623, P651, P2638, P1265, as I just mentioned, P1644. Now, the defense has urged you to disregard such entries, focusing on what may not be known about the notebooks and darkly speculating that they may have been fabricated. Setting aside the extent to which these notebooks are filled with mundane aspects of daily life and inconsequential detail, or so often require reference to additional contextual information for their significance to be understood, or even more importantly, that the notebooks must be assessed in the context of the totality of the evidence, they are corroborated both broadly and specifically. The trial record contains extensive submissions on corroboration of such items, including through item-by-item explanations in admissibility litigation and in our final trial brief. But for now, let me just give a couple of examples, if I may. Again, the next slide is not for public broadcast. This is P75, a notebook related to the posteric zone provided by the ICTY. And just flipping through its pages, you can find entry after entry that was corroborated during the course of this trial. And again, the following slides are not to be broadcast until I announce the next public item. Page 9244. The highlighted references were corroborated by witness 3873 at transcript T22578 through 79. 9253 and 9256. Highlighted portions corroborated by W4371 at transcript 15253 and 254 and 258 through 259. 9254. The date was corroborated by AF 467. 9270. Highlighted section is corroborated by P1381, which was seized from Jakub Krasniqi and confirmed by W4752 at T17355. 9274. Highlighted portions corroborated by W4371 at transcript 15258. 9278. Portions are corroborated by 4371 at T15257 through 58, and more. 9291. Highlighted portions corroborated by P1417, which was seized from Rajab Salimi, and P3837, which was seized from Jakub Krasniqi, both corroborating the posteric numerical designation. 9295, highlighted portions corroborated by W4295 at 2116 through 619. 9298, corroborated by 4371 at transcript 15257. 9249, highlighted sections corroborated by witness 3873 at T22577 through 579. 9301, Ducagini zone code is corroborated by P1417 and P319, seized from Mr. Krasniqi and Mr. Salimi. And one more, 9269. Here we see Adrenat's victim as corroborated by W4489 at transcript 11772 through 774. That victim also appears in P74, another notebook. And here he appears under, quote, notes about Ardit's information, unquote, which concerns suspicious persons and collaborators. And we know that from the evidence that Ardit or Arditi was a member of the Vrin local staff intelligence who was indeed tasked with what P74 reveals him to be doing: the identification of suspected collaborators. And there also, we see highlighted the name of another suspected collaborator. That's in the middle of the page to the left. And now looking at P1112, we see those same two names. P1112 was seized from Jakub Krasniqi. Or perhaps instead of a notebook, let's look at collected notes, also not for public broadcast. P1644 are notes seized in Likovce, Lauscha, and Aučareva during operations of the Serbian MUP in the first week of August, during the offensive that overran KLA headquarters following the attack on Rohovec. As Sokol Pashota told the ICTY, the KLA had written materials and, quote, then there were a lot of offenses and a lot of things were lost. And we see on 098615 through 98619, the information on these pages, Your Honors, was corroborated by W4337 at transcript 5310 through 19 and by P283. At 98618, witness 4290 confirmed his signature, and he did that at transcript 2505 through 07. And the references to asking Daya and Hockey for weapons are corroborated by the information you can find at paragraphs 462 through 463 of our final brief. At page 98621, the 6 names highlighted here can also be found in P2459, listing the same 6 as, quote, persons being looked for.
It's your microphone against the, thank you.
Is there still difficulty hearing? Okay. Turning to page 98619 of P1644, we see here the interrogation of one detainee who's asked about a number of people, including the highlighted name. And that person, the person being asked about, also appears in P709 and P1445, which were seized by UNMIK from Halil Chadraku, who you will recall was head of G2 of the intelligence service in the Pastrik zone. Those exhibits relate how a KLA soldier received a task in April '98 from her superiors, Femi Ladrossi, Musa Yashari, and Yahir Damaku, as a condition for joining the KLA. The task was to liquidate a skriptful, a term used to denote collaborators, also used by Recep Salimi in his November 1997 speech. And that skriptful was the person whose name you saw in 1644. The assignment was carried out, but the victim survived. When told in August 1999 that she'd be transferred to Drenica, the soldier was concerned because that's where the victim, who knew she was the attacker, lived. So the soldier then sought the assistance of Mr. Chadraku, who wrote to Tahir Sanani at the Pastrik Zone Command, urging that the soldier be protected in light of her service. Sanani wrote back that she was to take up her duties, quote, only after receiving the written order from Chief Lully. And continuing with P1644, 98623 to 6225 are 3 pages. And on those 3 pages, you see the names of 3 men, names and personal details, of 3 men abducted on 3 separate days from 3 separate locations, as described in paragraph 314 of the final brief. And at 98620, here you see a list of questions. When did you first hear of the KLA? Who's in the KLA? What do you think about the Albanian people? And so on. And in P1499, a chilling video, we see those same questions being asked of those men and of a 4th man. That video gives you a small insight into the despair and helplessness of being detained and fearing, or even worse, knowing what awaits. And you can watch one of those men as he says, quote, "I am destroyed, a living destroyed man. Just the thought that your little children are waiting and that I cannot bring up my children through life tomorrow." And on page 98615, we can see how the 4th man, a 58-year-old retired accountant, got there. Brought in by the Plumba unit, which was led by Ferhat Shala and which reported directly to the General Staff, and to which Recep Salimi assigned codes, and received by Sahit Yashari, who you heard on video in May 1998, saying, "The military police of Kosovo Liberation Army are professionally prepared and always ready to carry out the orders given by the General Staff of Kosovo." Those 4 men were never seen alive again. These overlapping strands of evidence among so many others reflect not only the extraordinary body of evidence that has been introduced, but the manifold ways the common purpose and those behind it manifested itself over and over and over. And during this time, the message from the General Staff about collaborators remained the same. We are targeting collaborators. Communique number 47, and this is public, issued on 12 May, stated that during the months of March, April, and May, at the orders of the Kosovo Liberation Army General Staff, a number of attacks were also carried out against certain Albanian collaborationists who, despite earlier warnings, had not given up on their anti-nationalist path. And you'll recall that, among other things, this was the period of the attack we just referred to, orchestrated by Damaku, Ladrossi, and Yashari. Communique number 48, issued on 19 June 1998, stated that by order of the General Staff, military formations carried out armed attacks against enemy forces and, quote, also took punitive measures against some incorrigible collaborationist elements. General Staff spokesperson Jakub Krasniqi, who in his own words, quote, represented and publicized the policy of the General Staff and KLA at that time, P799, confirmed that the General Staff was targeting collaborators in an interview of 11 July, which he also confirmed in testimony before the ICTY was accurate. He was asked about criticism of the KLA by the international community for violation of human rights of Serbian and Montenegrin civilians. And he responded with a memorable combination of admission and attempted evasion, answering, quote, "We do not go in for kidnapping. Even if some people have suffered, these have been more Albanian collaborators than Serbian civilians." That's at P793. All of this at the same time that the General Staff was preparing and disseminating regulations that codified the targeting and, quote, merciless treatment of opponents. Now, the defense has also asserted that what was called the KLA was merely a collection of disparate and autonomous units, and thus any detentions of and crimes against opponents cannot be attributed to the accused. But the KLA and the General Staff from its inception comprised a close-knit grouping with certain long-established strongholds. No one is suggesting that bringing all the village units under its authority occurred instantaneously. It was, instead, a process, and one to which the accused were devoted, and which was remarkably successful in a short period of time due to that leadership. But let's look at a few places where the targeting of opponents was unmistakably and brutally implemented to explore the question of connection between those sites and the General Staff. Likots was the Drenica Zone's headquarters and the zone's military police headquarters. Find that in the SPO final brief at paragraph 636. Was a hub from which recruits were deployed to other areas, and indeed the General Staff was headquartered there from March until the end of May 1998. That's P776, 44 through 48. It also held a detention site that was well known and feared among the local population, which held civilian detainees including farmers, teachers, elderly persons, accused of such things as being collaborators, LDK supporters, spies and traitors because they supported Rugova, not leaving employment, or showing submission to the occupier by distributing birth certificates. Prisoners were brutally mistreated and killed. The commander of Likots was Suleiman Salimi, Recep Salimi's close relative, who in fact introduced him to Adam Yashari. In May 1998, Suleiman Salimi was selected as Drenica Zone commander at a meeting attended by Recep Salimi, and his appointment was approved by the General Staff. Suleiman Salimi explained that, in addition to the many visits by Hashim Thaçi and Kadri Vaseli and Sokol Bishoda, Recep Salimi was always present in the area. Find that at P1745. And in an interview at the end of July 1998, Suleiman Salimi was asked, quote, "Who deals with the execution of sentences against collaborators and abducted Serb criminals?" A question which itself reflected the open secret that opponents were being targeted. Suleiman Salimi acknowledged the detentions, but, taking his lead from Mr. Krasniqi, stated that everything was done according to military law. The deputy commander was Sami Lushtaku, an old comrade of Recep Salimi, who re-entered Kosovo with Mr. Thaçi and Mr. Vaseli immediately after Prekaz. That's P771 and 773. He personally informed one beaten detainee that he and his father had been detained because of allegations that they were spies, and he gave an interview in May 98 in which he acknowledged that, quote, "We have killed police officers, soldiers, and their collaborators." That's P1266. Sahit Yashari was commander of the military police, another longtime comrade from the early days of the KLA, and we've already referred to his allegiance to the General Staff. And Sabit Getzi. He headed a unit in the Drenica Zone, including at Likots, and answered to the General Staff, and in particular, Kadri Vaseli. It was from Getzi's house that Mr. Salimi went to deliver his speech for the KLA's first appearance, and whom Mr. Salimi met very often in the spring and summer of 1998. Find that at the final trial brief at paragraph 315. all participated in the mistreatment of detainees. Let's look at one more place before the break. As detailed at paragraph 676 and onwards of the SPO's final brief, Jablonica was a site where civilians were held in subhuman conditions and brutally mistreated because they were accused of being spies and collaborators. And there, the commander was Lahi Brahimi, a member of the general staff with long-standing ties with the accused. Mr. Vaseli hid in Brahimi's home in Jablonica in the early 90s, and it was Brahimi who proposed Vaseli's alias Luli. From the mid-1990s, Salimi frequently met Brahimi and stayed at his house in Jablonica, organizing weapon shipments and planning military activities. Between 95 and March 98, Mr. Thaçi and Mr. Brahimi, one of Thaçi's main points of contact in Kosovo, met once or twice a year. Brahimi was also present at a meeting of the Dukagini Command, which adopted rules providing for the execution of collaborators with the enemy. When a group of village elders came to plead for the release of a prisoner, Brahimi refused them and asked them why they were not fighting, declaring Rugova a traitor and a supporter of Serbian authorities. And on another occasion, he accused a detainee and others from his village of being, quote, LDK supporters and, quote, traitors because they had fled an attack by Serbian forces. Brahimi himself took part in the arrests and mistreatment of detainees. And, Your Honor, this would be an appropriate time for a break.
All right, we'll take a half-hour break.
Mr. President, I just wanted to point out that some of our team may be coming in and out in the various sessions, and I wanted to let the panel know that in case the panel has any issue
Just
with
to
that.
do it quietly and not let the door slam.
I just in the breaks, not while we're speaking. Thank you.
We'll be back at 11 o'clock then. Thank you.
All rise.
Be seated. You may proceed, Mr. Teeger.
Thank you, Mr. President. And for the benefit of the registrar, all the remaining slides will be public until I indicate toward the end of the presentation those that cannot be broadcast. Your Honors, perhaps we'll look at one more detention site during this spring through early summer period. And that's Lapushnik. As detailed in paragraph 698 and onward of the final trial brief, over 100 civilians were held and subject to brutal and even horrifying treatment because they were labeled as spies and collaborators, including because they were LDK members. The Cheliku 3 unit operated the site, and its commander was appointed by and reported to Fatmir Limai, who himself was personally involved in the detention site. Limai joined the KLA in 1996 through his friend Recep Salimi, with whom he shared a home during their studies in Pristina. After fleeing Kosovo in 1997, Limai returned with Hashim Thaçi and Kadri Vaseli in the immediate aftermath of Prekaz and took up command, operating under the authority of the General Staff, conveying orders from and reporting to the General Staff, P 1812. Limai publicly proclaimed that units in the area were under the command of the General Staff, told Toronto Television that it was his, quote, duty to repeat the position of the UCK General Staff that there can be no talks about Kosovo without the KLA, and later became a member of the General Staff as head of the Military Police Directorate. You can see that at P4146 and at our final trial brief, paragraph 281. In Lapushnik, Limai told a detainee that he had been arrested because he sold wood to Serbs in Roma. That's at T20422. A notebook later seized from Limai's apartment contained notes on suspected collaborators, including a forester who was detained in Lapushnik and executed on the Berisha Mountains in late July 1998, P2018. Limai had frequent contacts with the General Staff. The frequency of his communication and contact was such that Recep Salimi assured the ICTY in defense of Limai that there couldn't have been a detention site there without his knowledge. That's final trial brief, para 599. Your Honors, whatever was happening in locations not yet under the authority of the General Staff during this period of rapid expansion, the common purpose was implemented in sites run by those they installed or appointed, who made clear they followed the General Staff, who they had known and worked with for years, and who knew best what they wanted. And speaking, as I cited Recep Salimi doing a moment ago, of being in places where there could not have been detentions without knowing about it, I've alluded to the accused extraordinary organizational efforts in this period, which put them in so many places so often. Let's just look at a few. As noted earlier, Thaçi, Vaseli, and particularly Salimi were regularly in Likots in that period. Indeed, the General Staff was headquartered there through May, when the 4 men, abducted on 4 different days, were interrogated for purposes of propaganda, the province of the General Staff, pursuant to a prepared template. When the Balacevac mine was taken in June 1998, it was extensively covered by the media, documented in international reports, and widely known. See the final trial brief at 1097, paragraph 1097. Thaçi and Vaseli went there after it was taken, and they can be seen in a still photograph reflecting KLA control and in a video with weapons. 9 mine workers were abducted by the KLA. That was no secret. Negotiations were held in a vain attempt to secure their release. They were never released and never seen again. Find that in the final trial brief at paragraphs 377 through 78. Just a month later, Rahavac was taken briefly by the KLA. Now, although the General Staff had concluded that they were not quite ready to take towns like Rahavac, someone jumped the gun, prompting a significant counteroffensive. The KLA General Staff, including Thaçi, Vaseli, and Salimi, responded immediately, appointing Agim Chelai to command and participating personally. And you can see paragraphs 232 and 792 of the final trial brief. Over 50 civilians were abducted in Rahavac, Aptarusha, and Reti. Reports written during or in the aftermath of these record in a matter-of-fact manner the taking of civilian prisoners, referring, for example, to, quote, 22 individuals would be taken prisoner, 7 women would be released. That's P67. Indeed, the General Staff would later brag about releasing the detained women to the ICRC. That's P4155. But bragging about releasing the women begs the question of what happened to the men. And you can see the General Staff responsibility for that chillingly laid out in paragraphs 792 through 817 of our final trial brief. Now, the defense has argued that the evidence of a particular witness cannot be credited, suggesting a motivation that is frankly hard to square with that person's actual involvement, as corroborated by others, such as W498, or indeed with the risks involved. The detail, depth, and context of the information provided by that witness long ago is compelling and persuasive, particularly given the corroboration, including corroboration by victims, the number of units involved under general and direct general staff authority, 2 separate KLA reports, P67 and P1329, recording in a matter-of-fact way the taking of civilian prisoners, that between the 2 major executions and discarding of bodies in the same area, an international who had heard from the ICRC in Malasheva about abductions raised the general issue of abductions and ICRC access to Mr. Thaçi and Mr. Vaseli, with the still living prisoners in the police station close by. Mr. Thaçi and Mr. Vaseli did not say, "What detentions? What are you talking about?" Instead, they blithely assured the representative, the international, that the KLA would respect the Geneva Conventions. And later, as mentioned, bragging about having released the women. Throughout the period I've discussed, spring and summer 1998, the targeting and mistreatment of opponents, which had been a hallmark of general staff efforts even before March 1998, was evident everywhere they went and everywhere they installed their most trusted subordinates, as well as in their statements, communiques, and regulations. The attack on Rahavats prompted a fierce response by Serb forces, overrunning KLA headquarters and brutally forcing out civilians from those areas. Faced with questions about the extent and necessity of the suffering and the effectiveness of the KLA and its strategies, or simply what was next, the General Staff saw danger and opposition and cast deviations from General Staff dogma as, quote, special war. Special warfare was deemed to include such matters as speculation about the institutions that were to represent Kosovo, spreading information that created a feeling of panic, sowing defeatism, calling on people to give up weapons, calling for a temporary solution of Kosovo's status, and was to be dealt with mercilessly. The KLA and the Albanian people declared the General Staff, quote, was being stabbed in the back by collaborationist and pacifist elements, unquote. In August 1998, for example, General Staff Political Declaration 7 warned of a, quote, merciless blow to anyone conducting special war by, quote, speculation on institution building, a project that the General Staff had embarked on in response to international interest in a single interlocutor and was determined to control. On September 18th, the General Staff stated in communique number 53 that, quote, various punitive actions are being taken against collaborationist elements who continue to serve the occupying rule. And on September 21st, in communique number 54, declared that, quote, all sorts of emissaries have put themselves at the service of the enemy by waging special warfare against our liberation war and heroic army, collaborationists and political activists who sow defeatism. Those two communiques bookended Chirez on September 20th. In Chirez and Baitsa, Mr. Thaçi, Mr. Salimi, and Sabit Getsi, again, led the arrest, detention, and beating of parliamentarians conducting a humanitarian visit to different parts of Kosovo with the approval of Ibrahim Rugova. As explained in a KLA military police press release, quote, based on information from the KLA Intelligence Service on 20 September 1998 at about 12:15, the KLA military police arrested 13 syndicalist, institutionalist party representatives in the village of Chirez, Drenica, for their divisive, partisan, schismatic, institutionalist, anti-liberation war propaganda, for handing over weapons, and for a temporary solution of Kosovo's status, and noted that investigations were continuing against 3. And just in case the detentions and beatings failed to deliver the message, shortly before they were released, Getzi threatened to kill Agam Krasniqi in Thaçi's presence, and Mr. Thaçi himself threatened another victim for refusing to resign from his political positions, telling him, quote, "Even if you are free now, we could kill you in Pristina because we have our own people in Pristina." That's at paragraph 940 of the final trial brief. The General Staff continued its focus on opponents viewed as engaging in special war. In the first week of October, Mr. Krasniqi underscored in an interview the, quote, special war effort by those trying to justify a peaceful path by speaking about KLA losses, and thus trying allegedly to, quote, destroy the KLA, P3713. On the 30th of October, LDK officials Jakub Kastrati and Sendescu were arrested. And you'll find at paragraphs 956 through 959 of the final trial brief detailed information about what happened to them. KLA military press release number 4 explained why. They had allegedly, quote, spread propaganda about surrendering weapons in cooperation with collaborators, namely Selman Benici from the village of Banja and Ramiz Hoxha from Belanica, who had been executed some time ago by the KLA. As Bartel Mahmoudi told U.S. diplomatic representative Larry Rawson in response to U.S. concerns about the detentions of these 2 LDK officials, quote, in this case, we have to do with 2 spies, collaborationists of the repressive Serb apparatus. They have been arrested because they have caused damage to our cause, unquote, and added that only the General Staff had the authority to allow anyone access to them. That's P1090. Similarly, Walker was told by a General Staff representative during the release process, quote, these are 2 Albanian traitors whom we tried, and they will not do it again. That's T2312 through 13. And the panel will recall that Selman Benici and Ramiz Hoxha were executed, indeed executed, and left by the side of the road. A handwritten, quote, execution order issued by the KLA Secret Police Service attached to Hoxha's body read, quote, for collaborating with the occupier and spreading anti-Albanian propaganda, causing fear, panic, and hatred in the name of the Albanian people and in the name of our war of liberation, Ramiz Hoxha from Belanica is sentenced to death as a traitor of the nation. Such a fate awaits any other traitor. And that's the final trial brief at paragraphs 88 through 89. The same military police release also asserted that Descu and Kastrati, quote, are in continuous coordination with Agim Krasniqi, a member of the LDK presidency, who is known to the KLA intelligence service as an inspirer of the special war against the KLA and an initiator of a kind of autonomous police in Kosovo. That special war justification for the arrest of Descu and Kastrati was echoed in P1250, a decision of the, quote, KLA military court justice judge based on information by the KLA intelligence service. Information that Kastrati and Descu, since the beginning of the enemy offensive, had, quote, carried out a special warfare against the KLA and our people's war for freedom and independence. And how had they done that? Quote, they defended the wretched position of the party they belong to, which has always obstructed our people's commitment in the war for freedom. They spread insecurity, and defeatism. They did not help the Kosovo Liberation Army. On the contrary, they hindered and sabotaged its just war. And the General Staff ensured that special war was addressed widely. For example, at the end of December, following a General Staff meeting with zone commanders, Mr. Serapi issued a report based on written reports received from the zones regarding various issues. With respect to defense and safety, the report noted, quote, "Special units and military police provide special help by successfully facing the enemy's special war and its extended hand." That's at P228. Now, this intensification of the opponent policy with the KLA coincided with the KLA's heightened engagement with the international community in the second half of 1998. Now, this was a much sought-after breakthrough for the KLA and the General Staff, but it brought with it uncomfortable scrutiny that threatened this newly achieved status. So in July 1998, as noted earlier, W2144 met with Mr. Thaçi and Mr. Vaselli, reminding them of allegations about detentions and abductions and about the need for ICRC access. In September 1998, the Special Rapporteur of the Commission on Human Rights, Jerry Deenspear, expressed alarm at reports of abductions carried out by the KLA against Serbian and Albanian civilians, specifically denouncing the mid-July abduction of 51 civilians from the Rahovac area. And in Political Declaration number 16 from October 1998, the General Staff, which was, quote, "closely following Kosovo-related political and diplomatic activities," characterized Deenspear's, quote, "irresponsible," unquote, representation as an attack against our just liberation war. And in November, early November, representatives of Human Rights Watch met with Mr. Thaçi and Mr. Limaj to discuss specifically the arrest of 2 Serb journalists and more generally concerns about allegations of violations by the KLA, including harassment, intimidation, and killings. Find that at our final trial brief at para 591. Now, one of the responses to this heightened scrutiny and awareness by the internationals was Bislam Serapi's order of 28 November 1998. That's at T17640 and 43. Now, while this order was directed to increased centralized control over arrests and detentions, it must be understood in full context, including that centralized control over the targeting of collaborators was the problem, not the solution, that the General Staff in its communications had made clear it did not consider collaborators subject to protections normally accorded civilians, and in light of the continuing targeting and mistreatment of opponents. I spoke in connection with the March through July period about 3 detention sites. Let's look quickly at a couple of sites in this period. Baigora was a site of the Lap Zone Command Headquarters from July until mid-September 1998. During that period of time, at least 16 persons were detained there. From the beginning of October, the village of La Pastica was the location of the Lap Zone Command headquarters, and where the Lap Zone Command also maintained a detention site in a stable or cowshed. More than 50 detainees were held there, interrogated, beaten, and sometimes killed because they were collaborators. Accused for various reasons, including being too friendly with Serbs, selling wood, failing to shut down a local LDK branch, being a forester, and you can find that at the final trial brief at 880 through 910. The commander of the Lap Zone was Rustam Mustafa, Remy, a close associate of Recep Salimi's, and who in fact was with Mr. Salimi and Adam Yashari just before the fatal assault on the Yashari compound. Latif, was regularly present in these locations, both these locations, directing the beatings of detainees and personally participating as well.
Interpreters note the counsel is kindly asked to slow down when reading for the purposes of interpretation. Thank you.
To the interpreters. Those beatings were savage, and you'll hear more about that from Mr. Potch. You've also received evidence of Gashi's interrogation philosophy, reflected when he instructs an interlocutor in March 1999 that he should, quote, interrogate in 3-hour sessions, beating him up all the time, slowly and thoroughly. That's P 3551. These facilities were established and operated under General Staff authorization and direction. Remy established by Gora on the basis of the communiques, referring to what is otherwise blindingly obvious to anyone, that the General Staff condemned collaborators and opponents and called for the harshest measures in dealing with them. And Remy further explained, however reluctantly, that after that he received from the General Staff an order to detain collaborators that was a result of the special needs after the summer offensive. Quote, the giving of an order was done at that time where there were special needs after the summer offensives. P 693 on page 6. And as we've just seen, the General Staff indeed responded fiercely to the risk of eroded support in the aftermath of the summer offensive, labeling any alternatives to General Staff positions as special war, a traitorous offense. That message was personally delivered in LAP. Shortly after the General Staff discussed special war at a General Staff meeting on 16 August, Mr. Thaçi, Mr. Krasniqi, Mr. Salimi, and Zarapi traveled to the Shala and Lap zones and raised the issue of special war, including how to detect and address it. Among other responses, the Lap zone produced a special war brochure at the end of November, which explained that special war was, among other things, quote, calls for dialogue and a political solution, or indeed, quote, any strengthening of pacifism, unquote, because that, quote, might result in the KLA factor being ignored by the international community. That's P164. After that visit to LAP in August, General Staff members returned in late October, including Mr. Thaçi, Mr. Krasniqi, and Mr. Salimi, among others. That's P189, pages 8863 through 66 and 67, and P1264 at SPOE 128742. Notes seized from Recep Salimi's house and admitted as P181 reveal some of what was discussed on that occasion. Again, there was discussion about special war, which Remy assured was under control. Quote, special war and propaganda not present. The notes then reflect a discussion with Latif Gashi, who referred to one former detainee who had been released after discussions with Mr. Thaçi and particularly Mr. Salimi, and another detainee who was beaten to death and whose body was thrown into a shallow grave near the detention site, where it remained until after the war when Remy and other soldiers directed the family to the location. And the notes reflect Gashi describing the cover-up story to explain the death of that detainee who was beaten to death, as revealed by autopsies, executed by Serb police. You can find that at paragraph 867 of the final brief. For a variety of reasons, we assess these as notes taken by Mr. Salimi, that is P181. It's clearly an inspection of the type he did routinely at a time he is known to have visited. It is unmistakably Remy talking to a member of the General Staff given the topics and issues raised. Latif Ghashi asked if there were suspicions during the time, quote, you worked with the detainee who was released, reflecting Salimi's acknowledgement that he was the first one in the KLA to deal with that particular detainee. That's P53.6, page 19. And the style and cursive of the notes are similar to others, where the context also makes unmistakably clear it is him writing. And one more direct reflection of the common purpose before Ms. Lawson turns to 1999. You'll recall the MP statement, the military police statement on the 1st of November that condemned Castrati and Descu for their association with Agam Krasniqi, who was a member of the LDK presidency, who was considered, quote, an inspirer of the special war against the KLA and an initiator of a kind of autonomous police in Kosovo. So around that same time, KLA leaders, described in a cable as Thaçi, quote, and his colleagues, unquote, told United States representatives that they would never support a solution that did not provide for independence, that all Serb forces must leave, and, quote, insist that the KLA, not Rugova or anyone else, determine who will be future ethnic Albanian police force. Mr. Thaçi and Mr. Krasniqi met with United States representatives again on the 6th of November, when Hill's draft document for an interim resolution of the crisis was presented. And they rejected out of hand the concept of a new Kosovo local police force that would reflect the ethnic balance of the province, insisting that, quote, there's only one Kosovo police force, and that is the KLA's police, unquote, adding that any Albanian member of a new police force would be considered a, quote, Serbian policeman. That's at P1068. That position was echoed in the General Staff's assessment of Ambassador Hill's draft solution, seized from Mr. Krasniqi's home, which states, quote, no police force shall be set up in Kosovo that derives outside of the KLA police units. That's P3760. And so, on December 2nd, Mr. Krasniqi gave an order which reflected exactly the position that Mr. Thaçi and Mr. Krasniqi had told the U.S., that local police would be considered Serbian police and an act of disloyalty that was treasonous. KLA zone commands were instructed to issue orders to the KLA military police to arrest those people who, by showing loyalty to the occupiers, put on the uniform of the Serb police, quote, thus committing an act of treason towards the Albanian people. The Krasniqi defense has argued at paragraphs 542 through 48 of their brief that this order was not related to Hill's proposal because he was unable to recall any aspect of his plan relating to the local police, and that in any case, Hill's proposed plan never came into effect because it was superseded by Rambouillet, and that Krasniqi's order of 2 December instead, quote, refers solely to combatants who took active part in hostilities. That Hill's plan was ultimately superseded is patently irrelevant to efforts before that to keep it from getting traction. And more importantly, Mr. Hill testified that while he didn't specifically recall elements of his plan, he was, quote, sure that policing was part of it, recalled talking about it in the context of, quote, an autonomous Kosovo, and that there was concern when we talked, concern about local police, that the, quote, organization that controls police will control Kosovo, unquote. And he noted these were people who believed in full independence. That's at T 27, 736 through 38. Hill's actual testimony confirms the contemporaneous cables to which I referred earlier, which made clear that KLA concerns about local police were that they threatened independence in favor of a kind of autonomy. Further, in making the claim that the 2 December order refers solely to combatants who took part in hostilities, the defense is forced to argue that many months and many battles into the conflict, the deputy commander issued an order that combatants, whom they had previously felt free to kill, should now be arrested. Not because they engaged in combat, but because, quote, they are showing loyalty to the occupier. It is patently clear that the disloyalty they are showing, and that is somehow necessary to point out to zone commands, is that local police are people who have chosen to become part of, quote, a solution that did not explicitly provide for independence. Mr. Krasniqi's 2 December order was aggressively implemented, and the next slides are not for public broadcast. This, Your Honor, is a report dated 9 March 1999 from the intelligence sector of the Duqujin operational zone. It lists well over 200 alleged suspected collaborators, including about 40 simply listed as, quote, local police officer. One of those is this man highlighted. And in an operation, this is also not to be broadcast, in an operation on 25 March involving the coordinated efforts of intelligence and police, that man was arrested at 3 in the morning, confessed to all types of things, including, quote, information about 5 other local police, and now quoting from the written report of the intelligence sector, he, quote, is in possession of a local police officer's booklet listing the number. The person in question was executed by the unit of the 132nd Brigade on 25 March 1999. His body is buried in. From 3 a.m. in the morning to that quick burial. And you can see another intelligence report at that time for a further reflection of focus on local police, a March intelligence report expressing concerns about the leaking of information about KLA arrests and KLA executions. That's P3195.4. Mr. Salimi's notes reveal a meeting earlier that month at the Duqujini Zone Command during which developments around each zone were discussed, as well as the political situation. Additionally, the status of the military police and of the intelligence and counterintelligence sector was reviewed with the determination that, quote, intelligence and counterintelligence are functioning at satisfactory level, unquote. And in particular, there was discussion of, quote, data on local policemen. That's at P3206. Now recall, we just saw a moment ago P1592, the Duqujini intelligence report about collaborators that listed more than 40 people because they were local police in different areas. That was seized at Mr. Salimi's residence. Your Honors, you can find other reflections of the implementation of the 2 December order in Bob, for example, in the early part of March 1999, where detainees were arrested, detained, and mistreated because they were considered to be local police. Find that in final trial brief, prosecution's final trial brief, paragraph 1018. As just reviewed, Your Honors, the common purpose and the accused's deep commitment to it was revealed over and over and over again during 1998. now turn the floor over to Ms. Lawson to discuss his manifestations in 1999.
Thank you, Mr. Teeger.
You've just heard about the development of the openly articulated and actively implemented opponent policy pursued by the JCE members. By October 1998, contacts with international actors had increased, KVM was deploying on the ground, and the prospect of internationally brokered negotiations was materializing. As Mr. Teeger alluded to, this brought heightened scrutiny. There's no question that as a result, the KLA leadership tried to present itself in a more favorable light towards the international community, as it vied to be recognized as the decisive factor in Kosovo and to lead any and all negotiations. However, when it came to the continuing targeting of opponents and resulting crimes, there's also no question that this was a very thin veneer of pretense, as the JCE members simply sought to better hide and disguise what they were doing. And this is amply demonstrated throughout the evidence, but we can start with Mr. Thaçi's own words and conduct. And for this, I'm drawing on the evidence cited at paragraphs 951 to 953 of our brief. On the 10th of November 1998, Thaçi, accompanied by Limai, met with representatives of Human Rights Watch and claimed that 2 detainees whose arrests had received considerable public attention had been tried in absentia and without legal representation, and were now serving a prison sentence. When advised that the detainees should be released, they even represented to Human Rights Watch that they could not intervene in judicial proceedings or, quote, civilian judicial authorities, end quote. That's at transcript 7323. This meeting followed a press release by the KLA Military Police Directorate announcing the arrests, and one by a KLA Justice Directorate containing the purported verdict of the military court. When these detainees were eventually released, pursuant to a supposed amnesty to coincide with Flag Day, General Staff Communique 63 announced that the release proved the KLA's recognition of international conventions of war and its respect for the international community. That's at paragraph 962 of our brief. Defense attempts to cast doubt on the authenticity of public statements issued in the name of the military police and justice directorates, primarily on the basis that no such formal directorates existed at the time, fail to persuade. Not only do such press releases address contemporaneously significant factual developments about which certain of the accused had direct knowledge, including the detentions at Jerez and the individuals held at Sedlare. And not only do they do so in terms which reflect the accused's own representations about those events, but there's additional, uncontestable support for their authenticity. For example, taking the military police press release, that's P270.10, which incidentally was published in Corregidore on the same page with General Staff Political Declaration 16. A hand-annotated draft version of this same Military Police Directorate press release was seized from Jakub Krasnici's house. That's P586. Similarly, in respect of the Justice Directorate press release, P378, not only do we have Fatmir Limay, a law graduate, contemporaneously being introduced to Human Rights Watch as the head of the KLA Judicial Directorate, but seized from Jakub Krasnici's house, we have a decision of the purported Justice Directorate issued during that same time period in respect of 2 detainees held at that same location, P1250. While, even as described, the purported trial of the 2 detainees discussed at the meeting failed to meet applicable international standards, the idea that there had been a trial before any court was, quite simply, a lie. As Thaçi himself admitted to the ICTY in 2004, he knew that in reality the detainees had not been sentenced. And in his later SPO interview, an extract of which is on screen now, when asked specifically about this incident, Thaçi confirmed the KLA didn't have any judicial or legal process, adding that, quote, "This is something that has been made up," end quote. That the statements made by Thaçi and Limay in that meeting with Human Rights Watch were direct lies is supported by a multitude of other evidence, similarly confirming that no KLA court existed at the time. And that can be found at paragraphs 66, 246, and 953 of our brief. Similarly, in the LAP zone, when members of the OSCE requested to meet with detainees at the start of February 1999, they were presented with a small number of pre-selected, healthier-looking individuals who had exceptionally been permitted to clean themselves and had been instructed on what to say. The military police commander there explained the supposed trial process for detainees to the OSCE representatives in elaborate detail. Again, a false depiction of reality to placate the international community. As Zone Commander Rustam Mustafa testified before this court, there was, quote, "no process whatsoever," end quote, for detainees in the LAP zone. They were just detained. That's at transcript 5572 to 5573. Such deception not only demonstrates intent and knowledge, it also demonstrates the active steps taken to mislead international actors, something which each of the defense briefs are at pains to claim could not possibly have occurred. But additionally, and importantly, it reflected endorsement of the crimes by providing cover for their continuation. As described in our brief, a legal sector and military court were eventually established at the end of 1998. motivated in large part by the need of the KLA leadership to legitimize themselves in front of the international community. The court was under-resourced and ineffective, a point about which there appears to be agreement between the parties. However, the court and De Bruyne as its head were also marginalized and undermined. General staff members, including Salimi and Limai, intervened directly, releasing or hiding detainees, or otherwise bypassing the court entirely. Proceedings that did occur were summary and arbitrary. Death sentences were imposed and then altered based on personal relationships, and judgments were signed by persons who were not part of the court, including the Chief of Staff. But with what limited resources the court did have, it did not investigate anyone for the widely known abductions, mistreatments, and killings that had occurred up until that point. Instead, one of the first cases brought to the court in January 1999, and easily the most prominent of the few that were brought to it, was that of Blerem Kuchi, who was arrested at the General Staff Headquarters in the presence of Jakub Krasniqi, Recep Salimi, and Fatmir Limai. During a conversation the following day, Krasniqi acknowledged that Kuchi had been arrested and also threatened that anyone who did not respect the KLA program would be punished, warning that, quote, all tendencies, sabotages of pacifism, and corruption of KLA manpower have to be cut, end quote. That is P2094. A document seized from Krasniqi's house entitled The Pacifist and Farcist Movements for Undermining the Kosovo Liberation Army and its Objectives of Securing Liberation, and it was seized in multiple versions, mentioned Kuchi in the following way, quote, the heaviest blow inflicted on our war was struck first and foremost by the blocking of money needed by us, and secondly, by the insertion of Farcist officers who had joined up not in order to professionalize and assist the KLA, but to undermine the fight for freedom. The following are evidence of this. Tahir Zimai in the Dukajin, Blerem Kuchi in the Pastrik zone, and in the Dranitsa zone, Kamal Shakiri and Gani Getsi. That's one of the versions of that is P01111. Following a sham trial, in a process that included defending against allegations that he said that the KLA and the government should be united, P1107, Kuchi was sentenced to death. As reflected in contemporaneous documents, similar fates were planned for other opponents, who were intended to be brought before the pseudo-court on charges of treason, and those references can be found at footnote 244 of our brief. As such, the court served simultaneously as a fig leaf to place a false veneer of legitimacy over ongoing criminal activity, and was used by the JCE members as a further tool to be leveraged against opponents. The court was also reliant on the referral of cases to it, in particular by the military police or intelligence sector, paragraphs 251 and 264 of our brief. The absurdity with which this was applied is exemplified in the case of the Savage brothers, whose abduction attracted a high degree of international attention. Both brothers were beaten in KLA custody, with one dying as a result. Sokol De Bruyne went personally to the detention site and discussed the case with other general staff members. yet failed to ensure the initiation of any investigation into the matter, and simply ignored the direct evidence in front of him on the basis that no criminal allegation had been submitted. Both Blerem Kuchi and the Savlich brothers were detained at a site in between the village of Klečka and the village of Divjak, where the KLA General Staff was headquartered. And from late 1998 until the 22nd of June 1999, this site served as the designated detention facility of the General Staff and was operated by the military police. The detainees, which included both Serbian and Albanian civilians, were held for periods of time ranging from a few days to several weeks. As described at paragraph 974 of our brief, detainees there were brutally beaten, with Recep Selimi participating personally in the mistreatment on one occasion. 11 detainees were murdered. One of those victims was Imre Jafici. Being employed in the document office of the MUP station in Prizren, he was perceived as associated with the enemy and was abducted by black uniformed KLA soldiers on the 9th of March 1999. Although the defense have alleged that all police were combatants, having regard to Jafici's actual function, as well as the circumstances of his arrest and the reasons provided for it, it's apparent that in fact he was a civil servant employee who had no involvement in hostilities, and rather he was taken as a perceived collaborator. However, there's also no indication whatsoever that his detention was absolutely necessary for security purposes. Douglas Young, a KVM representative, was alerted about Jafici's arrest on the same day on which it occurred and took immediate steps to try and locate him. As described in Young's testimony and as contemporaneously documented by him, he obtained confirmation that Jafici was held by the KLA, having been shown Jafici's personal documents and informed by a person associated with Recep Selimi's nickname of 10 that Jafici was under the control of a, quote, higher formation, end quote. Indeed, Young was one of 2 witnesses to testify before the court regarding Selimi's knowledge of this abduction. And as detailed in our brief, in addition to Krasniqi, Selimi, and De Bruyne, others with direct knowledge of and or involvement in the detention site at Klečka included Veseli and Limaj, as well as at least 5 other general staff members. The establishment of the court, as mentioned a short time ago, also served an additional important function for the KLA. And that was as part of the institution building exercise designed to advance its quest for authority and control. Political Declaration 17, on screen now, and if I haven't mentioned already, all of the slides that I showed during my presentation may be publicly broadcast, was issued in November 1998. It reiterated familiar themes, including that no decision on Kosovo could be made without the KLA, that the KLA would not recognize any agreement reached without its participation, that others willing to engage in talks would be condemned. The, quote, autonomy supporting and institutionalist phalanx, end quote, were again described as comprising, quote, former UDB members appointed to ministerial posts, end quote. And the declaration also made the following claim of authority. The General Staff of the KLA would like to remind everyone that Kosovo already has its own institutions, its political leadership, its justice bodies, its army and police force, etc., that have earned their legitimacy before national and international bodies, end quote. On the 18th of January, 1999, a public statement, an extract of which is on screen now, was issued specifically in Thaçi's name as the head of the political directorate and confirmed that the KLA General Staff was building state institutions. The statement proceeded to again vilify Bokoshi, an attempt to undermine the LDK-affiliated parallel institutions. Having accused Bokoshi of, amongst other things, fratricide, Thaçi proceeded to claim that, quote, Bokoshi has financed the assassination and the assassination attempts of KLA commanders. His file includes plans for the liquidation of the general staff of the KLA and some distinguished personalities in Kosovo, end quote. While the agreement for creation of the PGOK, signed at Rambouillet on the 23rd of February 1999, indeed provided for the participation of the LDK, it came in the atmosphere of vitriol and incendiary allegations just described. Other evidence also contextualizes the conditions of complete subjugation under which the KLA leadership were demanding that such participation would occur. This is perhaps best exemplified by Krasniqi's own words. On screen now. In negotiations with the Bokoshi government representatives that occurred around the end of March 1999, Krasniqi had made the conditions for participation clear, as he himself described, quote, in the end, I submitted some requests to him, and he told me that he would consider them with Bokoshi. The requests were as follows. A, to recognize the KLA program. B, to recognize PGOK and to submit to the command of the KLA General Staff. C, to respect KLA regulations. D, to enter Kosovo. And E, his headquarters in Tirana to be handed over to the Ministry of Defense of the PGOK, end quote. As described in section 2A1A2 of the brief, well before the agreement for creation of the PGOK was signed, the KLA leadership had already been taking steps to establish governmental and administrative institutions with the express intention that these would lay the, quote, foundations of the future state power, end quote. That's P811.32. As such, Thaçi effectively used the 23 February agreement as a cloak under which to manifest the institutions of power that the KLA leadership were already pursuing. Political Statement 34, published on the 30th of March 1999, declared, quote, Dear fellow patriots, in Kosovo there are two institutions, the provisional government with Hashim Thaçi as Prime Minister and the Kosovo Liberation Army, led by its general staff. The others, Bokoshi and Bidzai, who appear abroad and in the name of these institutions, are fraudsters and war criminals, end quote. That is P575. And days later, Thaçi proceeded to announce the composition of the PGOK. The announcement indicated one vacant post for the LDK, named 4 LBD members, left one further unallocated post for the LBD, and assigned all other posts to the KLA leadership, including appointing JCE members into key ministerial positions. Salimi became the Minister for Public Order with authority over the police. Vaseli became the head of Sheikh, continuing his intelligence role. Azam Sula became Minister of Defense. And Krasniqi continued to frame messaging as government spokesperson. With the withdrawal of Serbian forces following the Kumanova Agreement, the accused sought to activate the institutional infrastructure that they had been putting in place for many months and assert de facto authority on the ground. As described in paragraph 40 of our brief, KLA units promptly seized and occupied key state infrastructure. And simultaneously, Thaçi appointed PGOK-affiliated mayors appeared throughout Kosovo. From the very first meeting with UNMIK in June 1999, the intentions of the Thaçi government were clear. As described in paragraph 41 of our brief, Thaçi, accompanied by Salimi, presented UNMIK officials with an organogram of the PGOK. When informed that UNMIK had exclusive executive authority pursuant to UN Security Council Resolution 1244, the KLA representatives responded to the effect of, quote, "Thank you for your help, but now we are in charge. We created the PGOK, and now we run the country," end quote. Despite being repeatedly and clearly warned that the PGOK's actions encroached on UNMIK's mandate, Thaçi proceeded undeterred in issuing PGOK laws and decrees over key aspects of civilian governance, attempting to enforce a fait accompli. By the end of July 1999, Thaçi announced that the PGOK had achieved, quote, "horizontal and vertical spread of the government," quote, end quote, throughout municipalities. That is P4189. And Vaseli, too, had stated his intention to continue operating as head of intelligence even after demilitarization. Even defense witness James Covey acknowledged that Thaçi seemed intent on the PGOK's claims to administer Kosovo in contravention to the Security Council mandate. That's a transcript 27618 to 27621. He also noted that the expressions of antipathy towards Rugova seemed inconsistent with a fully democratic process, and acknowledged wondering whether Thaçi's real intentions were to clear the way for whatever party he might eventually represent. That's T27362 to 63. In fact, closer to the relevant time, Mr. Covey gave a much more direct assessment of events, writing in 2005 that, quote, "Over time, it became more and more apparent that this was not simply a heated political argument. KLA extremists would use any necessary means to displace Rugova and his LDK party apparatus, as well as to be acknowledged as heroes and the guarantors of Kosovo's future independence. KLA fighters saw the LDK's military arm, the Armed Forces of the Republic of Kosovo, FARC, as nearly as much of an enemy as the dreaded Serb Special Police. Even during the war, the KLA had attacked the FARC. In the vacuum that followed, the KLA's ruthless campaign against the LDK continued," end quote. That's P4496. The clarification Covey provided in testimony that this described what was being done by personnel associated with the KLA movement does not assist the accused. The evidence shows that throughout this time, the targeting of opponents did continue. Even after Kumanova, the military police and intelligence continued to cooperate in the detention and interrogation of civilians on allegations of collaboration. That's P1097.9 at pages 18 to 20. In fact, a communique issued by Agam Cheku on behalf of the KLA General Staff on the 23rd of June 1999 announced the identification of 3 alleged collaborators based on information from the intelligence services and the subsequent killing of 2 of them by the military police, indicating that the 3rd person who had escaped remained wanted. That's P1752. While the communique claimed that these deaths were the result of resisting arrest, the evidence shows that one of the victims was in fact murdered in the hospital where he'd been brought after being wounded in the initial attack. And that's described at paragraph 324 of our brief. This communique was published less than 48 hours after the KLA PGOK leadership, including Thaçi, Krasniqi, and Cheku, had attended the signing of the undertaking, pursuant to which the KLA agreed, amongst other things, quote, not to attack, detain, or intimidate any civilians in Kosovo, end quote. And that's P1444, paragraph 10D. Indeed, with the entry of K4 in June 1999, room for any legitimate detentions by the KLA PGOK was even more limited than previously. During that period, only detentions of the most limited duration in response to direct threats that could not be averted in sufficient time by K4 could be said to be absolutely necessary. The evidence shows that none of the charged detentions during this time period meet that criteria, and so, contrary to submissions otherwise, none were lawful. Throughout, despite the risk of his relationship with internationals, Thaçi would continue to push for consolidation of power and control for him and his PGOK structures, while simultaneously deflecting or denying crimes against opponents. To take just a small sample of examples, a cable recounting what is described as a difficult meeting on the 29th of July 1999, in which Thaçi was evasive on criminality and was described as, quote, testing out how far he could go in pushing UNMUC and K4 to accept UCK fait accompli, end quote, is noted at paragraph 45 of our brief. A subsequent cable from the 7th of August 1999 notes that, quote, Thaçi is still trying to consolidate the power base and executive role of the UCK on the ground, end quote. That's P1977. Even in November, well after the end of the indictment period, Thaçi was still attempting to coerce power. On the 15th of November 1999, Bernard Kouchner advised that Thaçi had indicated his intention to boycott UNMUC and K4 until they, quote, complied with his wishes, end quote. The following day, General Reinhardt, who had taken over from General Jackson as the commander of K4 in Kosovo, recorded the following observation, as you can see on the screen now. Quote, Thaçi is boycotting today's KTC meeting. His refusal to cooperate shows his contempt for the institution and the other members of the KTC. He is behaving like a child who sulks when it does not get its favorite toy. The toy he wants is the presidency of Kosovo and sole political leadership under the umbrella of Kouchner's administration, end quote. To finish, I'll address some of the additional specific arguments relating to the common criminal purpose made in the defense briefs. First, the Salimi defense argues that the objective of a JCE, rather than just the means, must be inherently criminal. However, the authorities cited say the opposite of what Salimi represents them to say. For example, the cited paragraph of the Brima appeals judgment very clearly explains that the requirement that a common plan is inherently criminal means that it, quote, must either have as its objective a crime within the statute or contemplates crimes within the statute as the means of achieving its objective, end quote. As explained at footnote 4 of our brief, this flows directly from the original wording of the Thaçi appeals judgment. Second, that there was a KLA objective of achieving independence in Kosovo in no way negates the objective on the part of the JCE members to gain and exercise control in the manner charged. Indeed, rather than being a counter-indicator, logic dictates that independence would have been a prerequisite for them to fully attain such control. And it's also a matter of both common sense and established jurisprudence that a person can have multiple simultaneous objectives. For example, Radovan Karadzic was found to have participated in 4 separate but related JCEs with distinct objectives. The defense briefs not only deliberately ignore this reality, but repeatedly attempt to elide the distinction, including by reference to the motivations of others. However, the motivations of ordinary soldiers for joining the KLA are in no way probative of the intent of the accused. W03165 is, for example, one of the witnesses relied upon for this purpose by both the Thaçi and Krasniqi defenses. That he personally joined the KLA in order to protect his country is not probative of the charges in this case. What is probative, and even more poignant in light of his service, is that less than 3 months later, his father was taken by black-clothed KLA soldiers, murdered, and falsely branded as a traitor to the nation. Third, the defense briefs claim that no direct evidence of the common criminal purpose was presented, and then proceed to make a range of arguments as to why one cannot be inferred. We've summarized in our brief, and here today, the wide range of both direct and circumstantial evidence demonstrating the existence of the common plan. A signed contract among JCE members is not required. But if the multiple contemporaneous public communications of the General Staff, as described in Section 2A1 of our brief, are accepted for what they clearly are, that's direct evidence of the common criminal purpose. If the contemporaneous public statements of the official General Staff spokesperson are accepted for what they clearly are, that's direct evidence of the common criminal purpose. If eyewitness accounts of the words and actions of the accused and other JCE members at multiple detention sites are accepted for what they are, that is direct evidence of the common criminal purpose. And this wealth of evidence is corroborated by other contemporaneous documentation, the manner in which structures and organizations were created and used by the accused, the regulatory framework put in place, the failure of the JCE members to prevent or punish crimes, and by the pattern of the charged crimes. The submissions that have been made simply don't displace the overwhelming volume of evidence proving the existence of the common criminal purpose beyond reasonable doubt. With regard specifically to personal motivations of direct perpetrators, while this may be a relevant consideration where there's an absence of other evidence connecting a particular crime to the common purpose, the mere existence of such motivations do not negate the common purpose, or even necessarily remove any particular crime from its scope. Indeed, a direct perpetrator need not share or even know of the common purpose. Rather, the relevant inquiry is whether a sufficient link between the perpetrator in question and a JCE member has been established. And a non-exhaustive list of factors which could establish such a link are set out by, for example, the Krajisnik trial judgment at paragraphs 1081 and 1082. In fact, in making these arguments about personal motivation, in particular with reference to the evidence of international witnesses regarding the atmosphere of revenge in the summer of 1999, the defense are largely seeking to create a straw man and responding to a case which has not been charged. The accused are not on trial for random criminality occurring during that period, or for the wave of general violence and house burning unleashed at that time against Serb civilians. The crimes charged are those committed by the accused subordinates, and consistent with and in continuation of the long-standing opponent policy. Notably, one of the examples used by the Thaçi defense in an effort to argue that perpetrators were not real KLA is W02951's disbelief that members of the, quote, real KLA who fought for freedom, end quote, would have done to him what they did. Not only does this again disingenuously attempt to play on the distinction between the KLA's fight for liberation and the unlawful violence endorsed and pursued by individuals within the KLA, but it carries no weight at all when placed in the context of the concrete location where this witness was mistreated. As set out in our brief, there's extensive evidence, including contemporaneous video evidence, demonstrating that the perpetrators there were indeed real members of the KLA. Similarly, reliance on W02652's testimony to argue that there was no general policy to target LDK members typifies both the distortion of evidence and disingenuousness of the points being made. We invite the panel to read the cited transcript pages. The witness is very clear in saying that, quote, the KLA as a term, end quote, did not have a problem with LDK members, but rather individuals within the KLA were opposed to the LDK, did the bad things, and refused to hold themselves accountable. And when given an opportunity on redirect examination to indicate the individuals being referred to, the witness specified that it was the KLA leadership at the main headquarters who pursued this opposition against the LDK. Moreover, contrary to speculative theories put forward in the defense briefs, for example, in the Thaçi brief at paragraphs 41 to 51, and the Krasniqi brief at paragraphs 165 to 169, the factual and legal questions before this panel do not require a dissection of various incentives or disincentives on the part of the accused to participate in the common purpose. Rather, the facts and conduct speak for themselves. As one of my colleagues will address in further detail later in our presentation, the accused did contribute, and with the requisite intent. Whether that was a rational choice, whether it was in their interests to do so or not, is beside the point. And finally, in relation to the pattern arguments raised. First, as already highlighted, the pattern of crimes committed is just one of multiple factors in this case, leading to the inescapable conclusion that the crimes were committed pursuant to a common criminal purpose. It's not the sole or even the main basis for inferring it. Nonetheless, the purported pattern analysis conducted by the Krasniqi defense is flawed both in concept and in interpretation. It forms the basis for an assertion that crimes committed were, quote, spontaneous actions of untrained individual actors, end quote, while either noting but disregarding or completely ignoring some of the most compelling evidence that this was not the case. Such as, just to take a few examples, the fact that crimes occurred not in random locations, but in and around KLA-run detention facilities, that many of these locations were major zone and regional headquarters, and even the General Staff's own official detention facility, that detainees were transferred between such facilities in an organized manner, requiring the participation of multiple personnel, the commonality of personnel, in particular military, police, and intelligence members involved in the crimes, the involvement of senior command-level personnel, and the commonality of the purported basis of detention and of the accusations made during interrogation in line with the charged criminal purpose. Mr. Patch will soon be speaking further about some of the common patterns in the charged crimes. However, the defense brief even makes the inexplicable claim that the alleged pattern shows that the General Staff were not involved in any crimes proven in the March to October 1998 period. This necessarily involves ignoring, amongst other things, the evidence of direct involvement of General Staff members, including certain of the accused, in the physical perpetration of those crimes. Indeed, in what's ultimately a fact-specific inquiry, the Krasniqi defense's heavy reliance on the Bagbo case is telling. There, in contrast to this case, crimes were primarily committed during demonstrations or attacks on neighborhoods, which frequently made it hard to tell the circumstances in which the violence broke out, and also involved quite disparate crimes committed by disparate groups and individuals. The Thaçi defense's selective reliance on the specific facts of Blagojevich are similarly revealing, and ignore the wide array of indicators from which a common purpose has been inferred, including, amongst others, a discernible pattern of crimes, that is, crimes not committed in a random or unorchestrated manner, and as with the charged crimes in this case, which were committed in and around detention facilities. Common circumstantial elements of crimes, some of which Mr. Patch will shortly touch upon. Use of diplomatic negotiations to regroup, as corresponds to the reorganization occurring in this case following the October 1998 ceasefire. Replacing members who impede the execution of the common plan, that is, people of independent judgment, with yes men who are willing to advance its aims, as well as promoting such people, as described in this case at paragraph 617 of our brief. Coordination amongst different units involved in arrest, detention, and interrogation, with the support of administrative decisions and orders that provide the legal, political, and social framework for the JCE. As described in detail throughout section 3 of our brief, including the involvement of military police, intelligence, and the transfer of detainees between sites. Statements of the JCE members, which correspond to subsequent attacks or crimes on the ground. As described in respect of this case, throughout section 2A1 of our brief, and clandestine operations to conceal crimes from international observers, including with the direct involvement of JCE members, such as actively covering up inhumane treatment at detention centers, precisely as described as this case at the start of my presentation. And for those factors, I was drawing there from, amongst others, the Sejnovic appeals judgment, the Simic trial judgment, the Martic trial judgment, and the Krajisnik trial judgment. And I will now hand over to Mr. Patch, who will further describe the pattern of crimes committed. Thank you.
Thank you, Councillor.
Good afternoon.
Good afternoon, Mr. Potch. You may proceed when ready.
Thank you. Earlier, my colleague set out how the accused formulated and shared the common purpose to gain and exercise control over all of Kosovo by means including unlawfully intimidating, mistreating, committing violence against, and removing those deemed to be opponents. I will be addressing the manifestation of those means, the charged crimes which took place in and around detention sites across Kosovo and parts of northern Albania. Each of these sites is represented by a black dot on the map appearing on your screens. Throughout my presentation, unless noted otherwise, slides are for public broadcast. The locations represented on your screens are those where the victims in this case were persecuted, imprisoned, illegally or arbitrarily arrested and detained, subjected to other inhumane acts, cruel treatment, and torture, disappeared, and murdered. The image before you now depicts the 437 incidents of detention which took place between April 98 and August 99. Each incident is represented by a blue dot in close proximity to the location of detention. While the number I provided includes persons detained at multiple sites, as noted in Schedule A to the indictment, what we provided there is a minimum number in terms of the incidents. Most of the victims were civilians not taking part in hostilities at the time of their arrests. As is clear from the plain meaning of its language, Article 14(1)(c) of the law, which reflects Common Article 3(1) of the Geneva Conventions, applies to all persons taking no active part in hostilities, in all circumstances, and without any adverse distinction. This therefore includes both detained members of opposing forces and members of one's own group. In this regard, I refer, for example, to paragraphs 711 and 722 of the Mustafa trial judgment and paragraph 547 of the ICRC's 2016 commentary to Geneva Convention 1. The blue dots on your screen represent farmers, teachers, business persons, retirees, those who socialize with Serbs, those who used to or continue to work in state-owned entities in order to make a living during the most difficult of times, those who didn't join the KLA or who didn't actively contribute to it, those who supported the LDK, those accused of being spies or collaborators, often based on generic, unsubstantiated rumors and speculation. Kosovo Albanian, Serb, Roma, Montenegrin, Bosnian, Macedonian. Men, women, and children. Indeed, the individuals whose liberty was unlawfully deprived through the accused conduct came from all walks of life. But as your honors read through our brief, and as you received and considered the evidence throughout the trial, you will have discerned that the targeting and mistreatment of these victims by KLA members under the accused's command and control followed similar patterns. As you heard earlier, opponents were identified by KLA members, including intelligence services and military police. The names of many of those arrested, detained, questioned, beaten, killed, or disappeared can be found in notes taken by KLA members. Such notes often contain details such as the prospective victim's movements or notes on or warrants for their arrest. By way of example, I refer to P75, a page of which is on your screen and not for public broadcast. Mr. Tiger showed this earlier.
You will recognize the names highlighted here from extensive evidence submitted in this case concerning their targeting and disappearance. Another example is P651, pages from which are on your screen now and also not for public broadcast. Here, you see an example of an arrest warrant for an opponent who was detained and mistreated in Yeshkova. You also see notes indicating that surveillance was being undertaken in relation to the same individual. Several of the victims were arrested from their homes or at checkpoints by masked or armed men. In most instances, KLA members failed to provide detainees with reasons for their arrest beyond inadequate generic assertions or allegations. Some were arrested after being ordered or summoned to attend KLA headquarters. For example, as you can see in the order on your screen from P1105, which can be publicly broadcast, Jakub Krasniqi, in his capacity as Deputy Commander of the General Staff, ordered KLA member Blerim Kuchi to report to the General Staff on 16 January 1999. On the date indicated in this order, Kuchi was arrested at General Staff headquarters in the presence of Krasniqi, Recep Selimi, and Fatmir Limay. You heard further details of this incident in earlier presentations. As mentioned earlier, in relation to cases such as this, where victims were members of armed forces, including the KLA, they are nevertheless protected under Article 14(1)(c) of the law. On a related note, when it comes to assessing whether a victim was protected, it's their activity at the time of the commission of the crime which is relevant. As set out in paragraph 602 of the 2025 commentary to Geneva Convention 4, quote, "There is no place for retribution under international humanitarian law," end quote. Thaçi defense submissions on the status of certain victims show a misplaced focus on former positions they may have occupied, rather than those they occupied at the time of their arrest or detention. Some such submissions are additionally also plainly inaccurate or misleading. For example, while the Thaçi defense mentions that 1338 worked for the police when he was abducted, no mention is made of his specific capacity, which is a relevant consideration. I invite you to look at paragraph 1121 of our brief in that regard. While 1605 had worked as a police officer, he was no longer doing so at the time he was arrested. Following their arrest, victims were transferred to and detained in locations used by KLA members, in many instances as KLA headquarters, offices, or barracks, or in close proximity thereto. In Jablonica, detainees were held at a barracks compound, an image of which is on your screens from P101. This location was a short walk from the local KLA headquarters at Lahi Brahimai's house. Just a reminder, unless I say otherwise, these can be publicly broadcast. Detainees were held in a room on the left of your screens, and also in rooms in the house on the right of your screen, which is also where Lahi and Nazmi Brahimai interrogated and mistreated detainees. Victims across the various sites were detained for various periods of time, ranging from hours to days, weeks, and multiple months. Documentary evidence corroborates witness evidence concerning charged crimes. including by contemporaneously memorializing detentions in black and white. P738, on your screens now and not for public broadcast, is a notebook containing a contemporaneous detention log showing the dates that 52 people were held at La Pastitza. As you can see on this page alone, several detentions lasted for weeks or months. For example, the person listed at number 9 was held for more than 5 weeks. The person listed at number 8 was detained for 4 months. Your Honors have received evidence that many of the detainees were restrained and/or blindfolded while they were being transferred or detained. Many victims were held in locked or guarded rooms and provided no or inadequate food, water, sanitation facilities, hygiene facilities, or medical care. In Bari, a victim spent 20 days of his 56-day detention in a dark, windowless, 1 by 2 meter room. He used a small box as a toilet. While this same victim was detained at another location, KLA members told him that they would kill him when he was as thin as a finger. He was rarely given water or food while detained, losing 38 kilograms over the course of his almost 2-month-long detention. In Lapushnik, detainees were held in inhumane conditions, including in both the storage room and the cowshed. One of the detainees described the conditions of detention as so dire that he thought death would have been a better option. Another detainee in Lapushnik hanged himself while he was detained there. While enduring harsh conditions at their location of detention, detainees were questioned, often before, while, or after being beaten. They were asked about their knowledge of or relationships with other individuals, including Serbs. Some were instructed to confess to crimes they did not commit. Many were accused of being spies, collaborators, or traitors. Many were questioned about or threatened in relation to their support of or role in the LDK. On approximately 24 June 1998, at the KLA headquarters in Brasans, Hashim Thaçi urged Kosovo Assembly MPs Abdul Rama and Uk Batuci to publicly resign from their LDK leadership positions and make a recorded statement supporting the KLA. Under pressure, Batuci acquiesced. Rama was threatened and mistreated by Thaçi when he defied Thaçi's demands. The Thaçi defense's characterization of the evidence concerning Hashim Thaçi's role in this incident fails to undermine the relevant, mutually corroborative evidence on record, including that relied on paragraphs 394 to 395 of our brief. Thaçi defense submissions concerning this incident ignore, in particular, relevant excerpts from the redirect examination of the witness mentioned, for example, at paragraphs 350 to 351 of their brief. The Thaçi defense submissions also ignore the plain meaning of relevant evidence, such as that from 4410's book, where, as you can see on your screen, he wrote, for example, Hashim Thaçi insisted that Uka give more powerful and decisive opinions on the KLA, but he had his own reservations. He wanted to say it in his own way, not for someone to impose it on him. Around 2 months after this incident, Recep Selimi was present and took notes while a detainee was questioned in Likovsk. Consistent with many other instances of detention by KLA members, on this occasion, in Selimi's presence, this detainee was questioned about his alleged collaboration with Serbian officials. the same detainee was repeatedly and viciously beaten at this detention site. By the time of this detention, Lickofts had already served as a General Staff headquarters and had hosted, or would go on to host, General Staff meetings, visits by the accused, and meetings with internationals. The following month, September 98, both Recep Salimi and Hashim Thaçi were involved in another incident during which detainees were questioned and mistreated. Thaçi and Salimi arrived at a local LDK office in Chires, while Kosovo-Albanian parliamentary delegation members were detained there by KLA members. Salimi and others transferred 13 of the delegation members to a school building used by the KLA in Bajce. There, a group of masked KLA members severely beat at least 6 of the detainees. Thaçi then interrogated the detainees with Sabit Getzi. Thaçi referred to the detainees as Rugovans and institutionalists. He demanded they resign from their parliamentary positions and write statements renouncing Ibrahim Rugova as a traitor. Thaçi was told that the detainees had been mistreated and saw their injuries himself. Thaçi and Sabit Getzi took the detainees to Krasmirovts, where Getzi, in Thaçi's presence, threatened to kill one victim. Thaçi himself threatened another victim. The Thaçi defense attempt to legally validate the delegation's detention by references to SPO powers to detain under the law regulating this court is symptomatic of the illogical nature of defense submissions in relation to this incident. As set out, for example, in the confirmation decision, the deprivation of liberty by KLA members would have had to be justified by criminal proceedings or reasonable grounds to believe that security concerns make it, quote, absolutely necessary, end quote. In the Shala case, a panel of the Court of Appeals Chamber noted that for the detention to qualify as absolutely necessary, there must be serious and legitimate reasons to think that the person concerned, by his activities, knowledge, or qualifications, represents a real threat to the detaining power's present or future security. The Thaçi defense's attempts to characterize the detained delegation's intention as being anything other than humanitarian ignores clear evidence and in no way indicate that a detention was absolutely necessary. The Thaçi defense attempts are as erroneous as the view Hashim Thaçi asserted during his SPO interview concerning the status of the delegation's members, as we can see on our screens now.
Interpreters note the council is kindly asked to slow down when reading for the purposes of interpretation. Thank you.
I will, thank you. What is on your screens is from P739.8. Contrary to what Mr. Thaçi asserts here, those forming part of the parliamentary delegation detained in Chires were civilians. Thaçi's distortion of the notion of combatant is a transparent attempt to justify his criminal activity. Unlike the Thaçi and Salimi defense's selective approach to the evidence concerning the Chires incident, the panel must consider all evidence in its totality, including documentary evidence such as Military Police Directorate press release P158. In relation to this and other incidents, the panel can and should rely on previous detailed, credible, consistent, and corroborated accounts of relevant witnesses where subsequent courtroom testimony by the same witnesses is transparently fear-driven and implausible. The panel should similarly rely on Thaçi's own earlier evidence concerning this incident, rather than his later attempts to walk back the truth. The images on your screen now are from Mr. Thaçi's January 2020 SPO interview in relation to the same incident. These should be publicly broadcast. At that time, at Baitse, did you witness any injuries on Mr. Dadai's person? I didn't see it, but I heard that he did, because he was clothed. But I didn't see anything on his face. Did you know at the time that he had been beaten or mistreated? Yes. With respect to Mr. Dadai and Mr. Bardi, how do you know that they had been beaten or mistreated if you did not witness it? I heard it from the soldiers that were present there. At the time? Yes, before I went to the school in Baitse. You had been made aware by soldiers before you went to Baitse that Mr. Dedai and Mr. Bardi had been mistreated? Yes. Who did they say had administered the beatings? They told me, but I also verified this when I got there. We will talk about this in the next interview. However, at that next interview, only 6 months later, the version of events Mr. Thaçi gave was inconsistent and illogical, alleging the injuries he referred to just 6 months before were moral, not physical. I'm here referring to P742.3. Unless he was referring to physical injuries, there is no fathomable reason why Mr. Thaçi would have referred in January 2020 to one of the victims being clothed as a reason why he did not see that victim's injuries. Neither would Mr. Thaçi have responded by saying, "They told me," when he was asked, who did they say had administered the beatings? Around a month after the Chires incident, Hashim Thaçi, with Fatmir Limay, questioned 2 Serbian journalists while they were detained in Sedlar. The fact that the victims themselves were not able to identify Thaçi as one of those questioning them does not detract from the evidence of 4839 who interpreted for Thaçi during the questioning. In its argument concerning this incident, the Thaçi defense asserts 4839 was unable to identify the nature of Thaçi's role. Yet the evidence they themselves cite in support of that assertion shows that the witness knew that Thaçi was in the political department. Regardless, specific knowledge of Thaçi's role in the KLA at the time of such questioning is of no relevance as to whether he took part in that questioning. In relation to the Thaçi defense's claims concerning 4839's reliability, including in relation to this incident, I refer your honors to paragraphs 1441 to 1447 of our brief. Threats and questioning of detainees by KLA members echoed threats in communiques and other public statements by the General Staff and members thereof. While transferring 2 victims to a detention site where they would be detained for almost a month, KLA members, who introduced themselves as from the General Staff, beat the 2 victims. They told them they would be punished with death, that Ibrahim Rugova is a traitor, and that the LDK is the UDP. Similarly, while arresting 2 other victims who would later be detained in Likovts, the KLA members told them they were going to liquidate them because they were with the LDK, traitors, and Serb collaborators. Once detained in Likovts, one of the victims was accused of being a spy and the collaborators. KLA members told him that they would kill all those who supported Rogova, and asked him why he was not on Hashim Thaçi's side. Such threats and questions echo, for example, the language in P269 ET.5 on your screens now. This is Communique 21, where the General Staff threatened it would be merciless against the occupiers and traitors, as we see here. P283 on your screens now, Communique 43, shows, as you can see, the General Staff, after calling on all capable Albanians to join the KLA, threatening death to the enemies and traitors. In P287, on your screens now, Communique 48, the General Staff called on all sound political forces to distance themselves from the intranationalistic, fraudulent, divisive, and anarchist policies on behalf of the fictive institutions attempting to eliminate the true national institutions and its KLA. The General Staff, as you can see, goes on to say, any action that jeopardizes the interests of the homeland and the aims of the liberation war will be condemned and punished. The language used by KLA members while they questioned and threatened detainees also echoed, for example, the threatening language used by Jakub Krasniqi, captured in P809, by Hashim Thaçi, reflected in P387, and by Recep Selimi, as emerged during testimony on 26 June 2024. Another feature of the charge detentions, which emerges time and again, is that detainees were provided no due process guarantees. In most cases, they received no adequate information concerning the reasons for their arrest or detention. Neither were they given an opportunity to challenge such arrest or detention. They were not taken before a judge or competent authority, nor were they accused or charged with any crimes or sentenced. As my colleague addressed earlier, Hashim Thaçi and Fatmir Limay lied about the existence of such due process rights in November 98 discussions with Human Rights Watch representatives. But even their lie, that two Serb journalists were being detained, had been tried in absentia without access to a lawyer, and were now serving representatives, showed a lack of due process. Indeed, as we saw earlier, years later, Thaçi confirmed that, quote, the KLA didn't have any judicial or legal process mechanism. That is something that has been made up. That quote is from P742.14. Due process guarantees were also lacking when the questioning at certain sites was occasionally conducted by KLA members acting in pseudo-judicial capacities. Your Honor, this would be a good time to take the break.
All right, we'll break for lunch now. You'll be back here at 2:30.
All rise.
We're adjourned.
All rise.
Be seated. For some reason, it's down. Lost their crowd.
Lost the entire audience.
Yeah. All right, Mr. Potch, I think we're ready for you to continue.
Thank you, Your Honor. Just before the break, I mentioned that due process guarantees were also lacking when questioning at certain sites. Is it okay now? I'm not sure I can fix it. Thank you. Just before the break, I mentioned that due process guarantees were also lacking when the questioning at certain sites was occasionally conducted by KLA members acting in pseudo-judicial capacities. By way of example, a victim underwent a sham trial at brigade headquarters where he was detained. While being beaten, he was asked questions, including about impeding the war effort and attending meetings with President Rugova. He was then informed of an order for him to be sent to the operational zone to which the relevant brigade reported. When he was transferred, he was subjected to another sham trial, this time on suspicion of, inter alia, spreading propaganda against the KLA. Operational zone staff questioned him on subjects including his involvement with the LDK. No evidence was presented against him, and he was not provided legal representation. Nevertheless, he was told that he was sentenced to several months' imprisonment. He was not provided the opportunity to appeal his sentence. The assertion at paragraph 275 of the Vesely brief that this incident was a purely local dispute is belied by the evidence, including that of the involvement of a plurality of KLA actors at both brigade and zone level, as set out in paragraphs 1080 to 1090 of our brief. That evidence includes testimony before this court, corroborated by evidence admitted pursuant to Rule 153 and documentary evidence. The obligation to respect the provisions of Common Article 3 is automatic and absolute for state and non-state parties to the conflict alike. Nevertheless, at paragraph 834 of their brief, the Vesely defense refer to an alleged obligation of due process, implying they do not accept that certain due process guarantees subsisted in the conflict. Their brief goes on to assert that any such obligation must be seen against the context within which the KLA operated and the KLA's level of development and tailored accordingly. No support is cited for that assertion. The immediately subsequent sentence of the Vesely brief cites to a footnote in an ICRC opinion paper, which notes that the great majority of non-state armed groups would not be able to provide habeas corpus. That does not assist the Vesely argument. As set out in the same footnote from the opinion paper, quote, there is, however, no doubt that IHL binds non-state armed groups that are a party to a NAIAC as evidenced by the relevant treaty provisions and customary IHL. As the opinion paper acknowledges, while Common Article 3, applicable in Nyack, does not provide specific judicial guarantees, it's generally accepted that Article 75.4 of Additional Protocol 1 may be taken to reflect customary law applicable in all types of conflict. Among the requirements of Article 75.4 of Additional Protocol 1 are that for the provision of information without delay of the particulars of the offense alleged and all necessary rights and means of defense, as well as the right to be tried in one's own presence. Even if the panel were to consider the KLA circumstances in assessing the applicable due process guarantees, given the KLA's level of organization and the nature of the fundamental and basic due process guarantees at issue, contrary to the Vasselli assertion, the law did not require the KLA to do the impossible. Communiques and other public statements, some of which we looked at earlier, were not the only general staff documents which were actualized in detention sites across Kosovo and northern Albania. As you can see in P166, rule drafted by Jakub Krasniqi, KLA members were instructed to, at all times, be merciless. They followed these instructions. They punched and kicked detainees all over their bodies. They beat them with bottles, baseball bats, wooden sticks, rifles, and metal bars. They stabbed them with knives, stomped on them, electrocuted them. In Klecz, Recep Selimi beat a detainee with plastic pipes. In Dobratin, military police members also used a plastic pipe when beating a detainee there. The beatings which many victims underwent at KLA detention sites resulted in serious injuries, including profuse bleeding, severe bruises, and broken bones. Victims in locations including Likovts, Bare, Zlash, Gjelan, Verban, Budakova, Yeshkova, Tusus, the MOP building, another location in Prizren, Kukes, Tsahan, Jablonica, Lapushnik, Malishev, and Klecz fainted or lost consciousness as a result of the severity of the beatings they endured or the harshness of the conditions they were detained in. As supported by Adjudicated Fact 676, the frequency of the beatings in Kukes meant that the detainees lived in a state of perpetual fear of further violence and death. At La Pashtica, detainees stated that he begged his captors to shoot him in the head rather than continue to abuse him. Some victims had their ribs or teeth broken, if not both. Detainees in both Verban and Lapushnik had fingernails pulled out with pliers. For the Lapushnik victim, this was an act of punishment for having helped another detainee whose fingers had been cut off. A number of victims were beaten in each other's presence or ordered to beat one another. Being beaten, often multiple times and with anything in sight, was by no means the only mistreatment or hardship detainees endured. Several detainees' property, including money and vehicles, was taken and never returned. In Bubel, detainees were made to saw wood or timber. In Kukes, detainees were made to unload trucks of supplies for the KLA or to clean rooms and toilets. In Budakova, detainees were forced to dig trenches. In Likovts, detainees were forced to clean blood-covered floors. In Lapushnik, detainees were forced to bury the mutilated bodies of co-detainees. In La Pashtica, detainees were driven to a wooded area. There, they were given a shovel to dig their own grave. Other forms of mistreatment detainees were subjected to further violated their dignity. In Thaçi, detainees were forced to undress and were kept in their underwear. As supported by adjudicated facts, a detainee in Thaçi underwent a mock execution. KLA members urinated on another detainee there. In Sedlar, parlous in the circumstances, a detainee removed his trousers and underwear after a KLA soldier ordered him to do so. Detainees also endured other forms of psychological mistreatment. In Verban, KLA members threatened detainees with execution. They also lied to detainees about their relatives having been killed. Many detainees heard screams or sounds of others being mistreated. As you can see on your screen, a detainee in Jalan stated, "While I was down in the room, I could hear screams from the other room. And when I say screams, I mean human screams, more like animal screams, cries. Those screams make your blood freeze in the veins. Here, if you heard it now, it would freeze people's blood in the veins. Those screams are unbelievable. And whenever he heard the screams, the one I have just described in particular, he would walk out of the room and go somewhere. And once he would open the door, the screams were even more and more intense." Besides the violent beatings, another common occurrence your honors will have no doubt noticed in the evidence is that KLA members transferred several detainees between various detention sites within the same town or village. Others were transferred to KLA-run detention sites in other areas, including in other operational zones, and from sites in Albania to sites in Kosovo. The evidence of such transfers and, for instance, the involvement of numerous KLA members in the arrest, transfer, detention, questioning, and mistreatment of an individual detainee is among that which should lead your honors to dismiss defense arguments that the crimes were individual acts of revenge and or the actions of rogue elements. By way of example, witness and documentary evidence, along with adjudicated facts now on your screen, establish that some of the several detainees held in Evaya in March 1999 had been detained in Bob immediately before. The 5 detainees who were not released when Serb forces began shelling Evaya were transferred to several other locations, including Varosh. 4 of them were never seen again. Multiple KLA members engaged in acts of physical brutality and mistreatment against some of the detainees. As we just saw, the facts of this incident were established during a previous trial. Much like is the case with other incidents, the facts and other relevant evidence make it crystal clear that the Krasniqi defense distorts reality in saying that any crimes that were committed were in response to Serbian attacks or to settle disputes. The Thaçi brief cites the testimony of one of the victims of the detentions in Evaya, where he says what you can see on your screen now. It is the evidence that when he was arrested, he was told, Now you have to deal with the KLA, which is of relevance here, not the witness's opinion that his detention was not a KLA matter. In relation to this and similar submissions made by multiple defense teams, the opinion of a victim or that of a relative as to why that victim may have been arrested or detained at times needs to be considered with caution. As witnesses have described, the stigma which comes along with being accused of collaboration follows you for all your life. In this context, it is understandable that certain witnesses would rely on anything but such an allegation when trying to justify their mistreatment to themselves or to others, including during testimony. As part of the same argument concerning other inferences from the charged crimes, the Thaçi defense asserts that all the people detained with 4337 were linked to his personal dispute. This is not supported by the evidence cited to at footnote 253 of that brief. To the contrary, evidence shows that during his month-long detention, his numerous co-detainees were detained for reasons unrelated to his personal dispute, including, for example, their support of the LDK, failure to stop at a KLA checkpoint, and interactions with persons of Serb ethnicity. In this regard, I refer the panel, for example, to P206 at pages ending 621, 623, 632, 633, and P202 at pages ending 836, 839, 840. Defense contentions in relation to the relevance of alleged personal motives of the direct perpetrators of crimes are unfounded. As set out in paragraph 1365 of our brief, the armed conflict need not have been causal to the commission of the crime charged, but it must have played, at a minimum, a substantial part in either the perpetrator's ability to commit that crime, their decision to commit it, the manner in which it was committed, or the purpose for or guise under which it was committed. Once this nexus has been established, the existence of additional personal motives, such as revenge, will not negate the classification of such acts as war crimes. The law is clear on the subject, as this court has acknowledged in paragraph 770 of the Shala appeals judgment. Turning back for a moment to the transfer of detainees by KLA members. At times, such detainees, once transferred, were never seen alive again. In June 1998, two opponents who had been arrested, interrogated, and in one case severely beaten at the Drenov's KLA headquarters, were personally taken in the direction of the KLA general headquarters by Hashim Thaçi and Kadri Veseli. Thaçi and Veseli were initially accompanied by Recep Selimi during the transfer. The two opponents were never seen or heard from again. Defense assertions concerning evidence relevant to this incident focus on alleged inconsistencies which, even if they were to be true, do not detract from the core of the witness and documentary evidence establishing the relevant facts. Unsurprisingly, the defense also attempts to downplay the strength of certain relevant evidence. Recep Selimi's SPO statement provides direct evidence of Thaçi's involvement in this incident, including because, in the same statement, Selimi implicates himself, and as such, this evidence is against Selimi's own interest. This excerpt of his statement is reliable. Contrary to the Veseli assertion, Recep Selimi did not retract his claim that Kadri Veseli was involved in the transfer. Rather, while he initially expressed uncertainty as to whether Veseli was present at the time of the incident, Selimi ultimately deferred to his better recollection of events in 2003 when he had asserted Veseli was with himself and Thaçi as they transferred one of the victims. And I'm here referring to P761.1. The Salimi claim that a witness manipulated, pressured, and threatened Salimi to provide information concerning this incident defies belief, including considering the incriminating evidence Salimi provided to the SPO concerning the same incident many years after such alleged manipulation. Veseli defense assertions that hearsay evidence in relation to this incident is untested ignore extensive cross-examination of relevant witnesses. The alternative theories concerning this incident posited in the defense brief are debunked by the evidence on record, including for the reasons set out at paragraphs 766 to 770 of our brief. The Salimi argument concerning the scope and consequence of the allegation relevant to Salimi is illogical and unfounded. The transfer of these opponents was not the only detainee transfer which Kadri Veseli was involved in. In March 1999, Veseli transferred a detainee from Janitz to Kletch prison after this detainee had been beaten and detained by KLA members. Another recurring feature of the evidence concerning the charged crimes is that at multiple sites, detainees were only released because of expected or actual Serbian offenses or KFOR raids, and in some cases, only after international pressure was exerted on KLA members, including on certain accused, to release the detainees. KLA members, under the accused effective control, didn't only treat their direct victims in similar ways. Even their victims' relatives were, in several respects, subjected to common behavioral patterns. They were often not allowed to visit their detained relatives, faced with refusals to acknowledge their relatives' arrest or detention, or not provided information about their fate or whereabouts. At times, they were provided with false information. Sometimes, relatives were themselves threatened, beaten, or detained as they desperately sought to learn of their loved ones' fates. The panel's jurisdiction over the crime of enforced disappearance, just as its jurisdiction over the crime of arbitrary detention, is established for the reasons set out by a panel of the Court of Appeals Chamber, in this case, in decision IA 9F30. The SPO relies on the confirmation decision in relation to the elements of both these crimes. Another commonality shared by relatives of multiple victims is their inability to achieve closure concerning what happened to their family members. The remains of victims detained in locations including Likovts, Jablanica, Drenovts, Kletsk, Varosh, Rahovets, and Neredim e Ulet have never been found. In relation to Neredim e Ulet and Novoberde, the Krasniqi submissions concerning relevant evidence omit key information. The admission of the evidence concerning the crimes at Neredim e Ulet, pursuant to Rule 155 and Rule 153, was not opposed by the defense. In relation to Novoberde, the evidence of the crime-based witness, which the SPO relies on, was admitted via Rule 153. After informing the SPO that it did not object to such admission, the defense did not file a response to the SPO's request to admit this witness's evidence under that rule. This means that the defense did not object to such admission, or otherwise indicate a desire to cross-examine this witness when given the opportunity to do so. This witness's evidence is reliable, internally consistent, and detailed. To the extent the witness addresses issues beyond the crime base, such evidence is corroborated by documentary evidence and the evidence of 4868, who testified pursuant to Rule 154. The crimes are also corroborated by, and form part of, consistent evidence of a pattern of conduct in the Caradoc zone and more broadly during the time period. In some cases where the bodies of murder victims were found, KLA members had deliberately left them in fields, roads, or other public places. The murder victims in this case are represented by the red dots appearing on your screen. As established by evidence, including autopsy reports, the injuries found on the bodies of some of these murder victims were similar. The bodies of victims detained, for example, in Likovts, Lapushnik, Malisheva, Barem Baigora, La Pashtitsa, and Kletsk, suffered gunshot wounds, often multiple, including to the head and chest, sharp cuts, or blunt force trauma. The expert evidence of forensic pathologists 4826 and 4874 assists the panel in this regard, as does other witness and documentary evidence. Other forensic evidence admitted in this case confirms the identity of murder victims through DNA testing. 4875's expert evidence assists the panel in relation to such evidence. Vesely defense arguments that forensic evidence admitted via the bar table was never subjected to scrutiny ignores the fact that the defense had the opportunity to make written submissions on any such item at the time of bar table litigation and in its final brief. The defense could also have used any such item with relevant witnesses, including the forensic experts who testified. Nothing precluded the defense from calling witnesses to testify about such evidence or seeking to otherwise tender evidence concerning such items. Vesely defense arguments that certain admitted autopsy and DNA reports cannot be relied on for the truth of their content should equally be dismissed, as they essentially attempt to relitigate an admissibility issue that has been the subject of an interlocutory appeal. In this regard, we rely on paragraphs 38 to 42 of our response IA 40 F6 in this case. Salimi defense submissions concerning the evidence of the circumstances of death of a number of victims blatantly ignore relevant detail and evidence. By way of example, I invite the panel to compare the Salimi defense submissions at paragraph 647 of their brief regarding the murder of 6 victims with paragraphs 651 to 657 of our brief and the underlying evidence that is cited. That underlying evidence includes specific death threats made by the KLA captors to the victims, the short lapse between the time the victims were last seen in KLA custody and when their bodies were discovered, a KLA soldier's inside knowledge before the bodies were even found that killings had occurred, and forensic findings indicating that the victims were killed in the same location, at the same time, and with the same weapon or weapons. When the relevant evidence is considered together, the only reasonable inference is that the deaths occurred at the hands of KLA members. Another pattern your honors will have noted is the involvement of KLA members at all levels in the commission of crimes. The named JCE members who occupied positions in the upper echelons of the KLA are by no means an exception. As confirmed by Recep Salimi, JCE member Sabit Getzi, like himself, was among those engaged within the KLA in 1997. Getzi headed an intelligence unit operating in Dranitz that answered to Kadri Vesely and the general staff. Kadri Vesely acknowledged that he knew Getzi and that he met him more than once, including in March '98 in Dranitz. The Veseli defense attempts to distance Veseli from Getzi primarily based on linguistics. They claim that Getzi introduced himself and was referred to in documentation as Secret Service rather than intelligence. This attempt fails. For example, in the provisional regulations of the internal life of the organization of the internal life of the Army, now on your screen, the General Staff itself referred to KLA Secret Service and intelligence entities as one and the same. As we can see, they refer to the duties of the military police to assist and cooperate with the, quote, Secret Service Directorate of Intelligence and Counterintelligence. Later in the conflict, Sabit Getzi held a position of authority at the Tsahan and Kukes detention sites and was Chief of Intelligence and Counterintelligence for Albania, reporting directly to the General Staff. A holistic consideration of the relevant evidence concerning Getzi establishes his intelligence positions and reporting lines to Veseli and the General Staff. Soon after his direct participation in crimes in Chires, Sabit Getzi traveled in a car to Albania via Ladrovts with Hashim Thaçi and Javid Ferizi, also known as Raketa. In addition to his involvement in Chires, Getzi took part in interrogations and detentions at Likovts and in arrests, detentions, interrogations, and mistreatments of opponents in Tsahan and Kukes in 1999, physically and psychologically abusing detainees there. After a victim later detained in Tsahan was arrested, Sabit Getzi declared, "We have the right guy because he's a supporter of Rugova." And Getzi asked, "Will Rugova be able to save you now?" He later told the same victim that he would be killed like all other LDK members. Many of the victims who made it out alive continue to suffer in similar ways due to their mistreatment at the hands of KLA members. Unfounded claims by KLA members that victims were spies or collaborators meant that victims and their family members continued to carry a stain which destroyed their reputation. It meant that they were treated as outsiders and were no longer welcome in their village. Victims of charged crimes have had to undergo medical treatment, including surgery. They continue to experience physical and psychological pain. Some were rendered infertile. Some are still unable to earn a living. Family members of victims were themselves traumatized by what happened to their loved ones. W72, whose determination for justice was highlighted by the specialist prosecutor earlier today, described the loss of her husband and of her son, both of whom were detained and killed by KLA members, as losing half of her heart. The witness told Your Honors that she will be thinking about her husband and son when she takes her last breath. 4489, a wife whose husband's remains have never been found, said that the silence kills and that it has killed her and others for a second time. 4367, a mother who decades after she last saw her son while he was being detained by KLA members, spends that son's birthday ceaselessly crying. The evidence provided by family members of the victims of murder means that although certain KLA members ensured that their victims never got to tell their story to anyone, Your Honors nevertheless received evidence about their arrest, detention, mistreatment, and killing. You also received evidence concerning victims of murder through co-detainees and KLA members brave enough to speak up. As to those victims who were fortunate enough to survive their mistreatment, you received evidence detailing what they experienced through various sources. Some such victims, despite fears for their own and their families' lives and well-being, worked up the courage to come to testify before you. In relation to these and other victims, Your Honours also admitted written statements documenting the crimes in detail, at times without objection by one or more defense teams. The witness evidence concerning charged crimes is supplemented and corroborated by extensive documentary and pattern evidence. While reviewing such evidence, Your Honours should bear in mind that the violent acts I have mentioned and those detailed in our brief were carried out on political and/or ethnic grounds, satisfying the elements of the charged crime of persecution. Although my submissions have mentioned several victims, detention sites, and forms of mistreatment, I barely scratch the surface of the evidence of charged crimes in this case. Our final trial brief sets out detailed submissions on each crime site at Section 3. The evidence of the accused's presence at crime sites and direct participation in crimes is set out in more detail throughout our brief. While the evidence I have touched on today is diverse in terms of its nature, it is mutually corroborative, leaving no reasonable doubt that the charged crimes occurred. In the next presentation, Mr. Quick will discuss the structure and functioning of the General Staff and of the KLA during the indictment period.
Thank you, Mr. Pach. Mr. Quick, you can proceed when you're ready.
Thank you, Your Honor. Just one moment. Good afternoon, Your Honors, and to everyone inside and outside the courtroom. Before I start, I just want to note that all slides I will use today are public, except for one, which is actually the last slide in my presentation. Your Honors, my colleagues have addressed the early formation of the KLA and the General Staff, the common criminal purpose, and the charged crimes. I will address the functioning and structures of the General Staff, Provisional Government of Kosovo, and operational zones. This includes their headquarters, decision-making and meetings, regulations, orders, communications, composition, roles, and reporting lines. The KLA was an organized armed group that was evolving in response to complex and ever-changing military and political circumstances. It was not a traditional army. Certain witnesses' opinions about organization, structure, and authority were based on comparison to the militaries of the former Yugoslavia, Serbia, or NATO countries. Such opinions provide little assistance in assessing the unique circumstances of the KLA. Of course, a distinction must be drawn between aspiration and reality. Some regulations and orders were, in part, forward-looking to a time when the KLA intended to control an independent Kosovo. Such advanced planning, in fact, demonstrates the organization of the KLA and the General Staff. The reality is that over time and across organizational change, the accused had authority over the structures in place and used them to execute their common criminal plan. Mr. Tiger has already explained that at the start of the indictment period, the KLA operated from established strongholds under the direct authority of the General Staff, including the accused and the named JCE members. The first charged crimes were committed at such strongholds. As KLA support and volunteers increased following the attacks on Likashan, Shiraz, and Prekaz, the General Staff, including the accused and JCE members, coordinated and directed the expansion of the KLA from its existing strongholds. They targeted strategic locations, they created free zones, they consolidated control. From May 1998, the accused and General Staff oversaw the establishment and development of operational zones where the charged crimes were committed. By at least early June 1998, the General Staff further divided responsibilities between its members, who nonetheless continued to perform a range of political and military functions as required. Before continuing with the functioning and structures of the General Staff from June 1998, the location of the General Staff's headquarters provide important context. They were chosen strategically to ensure that the General Staff could effectively operate and exercise control. The General Staff used a variety of locations, particularly in the Dranitsa, Pastrik, and Nerodim zones, for its meetings and headquarters. At the start of the indictment period, the General Staff was based in and operating out of Likovsk. From summer 1998, the General Staff was primarily headquartered in Divjak and nearby locations. These headquarters in the Berisha Mountains were at the center of Kosovo and the operational zones, facilitating General Staff oversight and communications, as explained by Fatmir Limay in the video P836. There are English subtitles on this video, so it does not need interpretation. I'll play the video now.
Të gjitha parakushtet që shtabi përgjithshëm i gjykës, duke marrë parasysh terrenin, i kishte vendin pothuajse më të sigurt vendosjen në këtë pjesë të Kosovës, nga ku do të ndërlidhte veprimet ushtarake dhe komunikimi me të gjitha njësitë ushtarake anë kënd Kosovës. Ky është pika, si thua, mesi i Kosovës, qendra e Kosovës me të cilën mund të komunikonte me të gjitha anët e Kosovës. Edhe në sistemin e ndërlidhjes, edhe në sistemin e kalimit dhe parakalimit të ushtarëve nga një zonë në zonën tjetër, duhet patjetër të kalojnë nëpër këto male dhe të ndërlidhen me zona tjera. Prandaj edhe ne vendosëm që shtabi i përgjithshëm i gjykës pjesën më të madhe ta kalojnë në këtë pjesë.
The General Staff's choice of secure and strategically located headquarters and meeting locations shows its organization and its adaptability. It maintained its leadership and oversight at all times. The General Staff made decisions by a process of collective deliberation, and majority decisions were respected by all. From spring 1998 onwards, General Staff meetings became increasingly regular, including expanded meetings to which zone commanders were invited. However, as explained by Shukri Bouya at transcript page 21992, when attending General Staff meetings, he, as a zone commander...
The speaker is kindly asked to slow down for the purpose of interpretation. Thank you.
When attending General Staff meetings, Shukri Bouya, as a zone commander, did not have the right to vote. After the creation of the provisional government in March 1999, joint meetings of the General Staff and senior provisional government officials were held. As set out in paragraph 112 of our brief, General Staff meetings addressed a wide range of matters, including appointments and dismissals, discipline, structure, regulations, intelligence and military police, arrests and detentions, treatment of collaborators and opponents, logistics, finances, and negotiations. After meetings, the general staff, including the accused, proceeded to issue orders, regulations, and public statements, and took action. For example, the order now on your screen followed a meeting on 27 June 1998 and authorized the military police and soldiers at checkpoints to detain suspicious persons. This order was seized from Jakub Krasniqi. While not every general staff member was present at every meeting, one or more of the accused regularly attended meetings. That Veseli and Thaçi were absent from Kosovo during certain periods in the second half of 1998 and early 1999 does not detract from their responsibility, their authority, or the part that they played in the collective decision-making process. All four accused were present in Kosovo for and attended meetings at which critical decisions were made concerning the organization and leadership of the general staff, the provisional government of Kosovo, and the future direction of each. Moreover, absent members were consulted and informed of decisions reached. The evidence demonstrates that there were always the means and the opportunity to do so. Records and meeting minutes were kept. Orders, regulations, and public statements referred to such meetings. Decisions reached related to the roles and activities of the accused. Meetings often followed up or related to matters discussed at previous meetings. The accused and other general staff members closely coordinated, were frequently together, and had various communications means at their disposal. Recep Slimi, in his SPO interview, confirmed that Hashim Thaçi and Kadri Veseli were consulted and informed of meeting outcomes when they were abroad. By way of concrete example, during the negotiations on the exchange of 8 captured Serbian soldiers in early January 1999, Jakub Krasniqi was consulting with Hashim Thaçi and other general staff members by satellite phone. At this time, as corroborated also by their travel documents, both Thaçi and Veseli were traveling and were together. As will be addressed further by Mr. Halling, the evidence demonstrates that they could and did communicate at a moment's notice with the leadership in Kosovo. Beginning in early summer 1998, the General Staff issued regulations governing military organization, discipline, intelligence, public relations, civil administration, guard duty, and the military police. These regulations asserted the sole authority of the General Staff, and they authorized arrests and detentions. Notably, they contained no guarantees of due process or humane treatment. Such regulations were disseminated. Non-compliance could result in disciplinary measures. The provisional regulations of the organization of the internal life of the Army formed the backbone of this regulatory framework. The General Staff also adopted internal regulations explicitly confirming itself as the highest commanding authority of the KLA. General Staff disciplinary regulations empowered superiors at multiple levels to impose a variety of sanctions, including confinement and dismissal. General staff regulations form the basis for a steady stream of orders and decisions, including at zone and brigade levels.
Propisi koje je izdao glavni štab bili su osnova za veliki broj naređenja i odluka, uključujući na nivoima zona i brigada.
We are getting your
Predsjedavajući, čekamo na prevod vaših reči.
Go ahead.
On your screen is the first page of a 3-page General Staff Register of Protocol Documents. This register was seized from Jakub Krasniqi, and it lists orders, decisions, and other General Staff documents. At least 25 of them are admitted exhibits. On the left side of the screen is the English translation, on the right, the Albanian original, and in the middle, the corresponding exhibit numbers. On this first page, you see several admitted orders to the zones, which continue to the next page. This page also includes orders to and concerning specific brigades in Pastrik, Dukajane, Niradim, and the General Staff Reconnaissance Battalion. The orders and decisions on these first 2 pages concern command unity, reporting requirements, appointments, training, logistics, taxation, communications, and authority to conduct arrests and detentions. If we go to the final page, there are 3 more admitted exhibits, including an invitation obliging zone commanders to attend a meeting in January 1999. And now on the next slide, we see the signatures and seals of all 7 zone commanders. They were recorded by the General Staff for identification purposes, including when distributing orders and decisions. This document was also seized from Jakub Krasniqi. The General Staff, including the accused, disseminated orders, received reports, and coordinated internally and externally through in-person meetings, radios, couriers, and mobile and satellite phones. The Thaçi defense submits that the KLA had no satellite phones before December 1998, with other defense teams making similar claims. The evidence presented at trial, including as cited in paragraph 219 of our brief, clearly shows otherwise. Indeed, in June 1998, the Dreadnought's headquarters, a charge detention site, had a satellite phone. P1259, read together with P1264, PDF pages 66 to 67, confirmed this. Your Honor, this would be a convenient time to break, if that would be okay.
All right, we'll take a break until 15:45. Please be back in court at that time. We're adjourned until 15:45.
All rise. All rise.
Be seated. right, Mr. Quick, you may proceed when you're ready.
Thank you, Your Honor. I will now turn to the general staff structure. The roles and positions of general staff members were discussed and decided at its meetings. Their duties and responsibilities were reflected in the general staff's regulations. The slide on your screen shows the general staff directorates together with the positions filled by at least June and July 1998. The yellow frames indicate the accused, and the black frames named JCE members. Certain boxes do not have names. Even if the heads of these directorates were not at least formally appointed until autumn 1998, the accused and general staff members were performing their functions well before, as set out for each in our brief. On your screen now are the positions in the general staff that existed from at least late 1998. As with the last slide, yellow frames indicate the accused and black frames name JCE members. The general staff composition throughout demonstrates the control the accused and JCE members, together with their trusted persons, over general staff decision-making. As he explained in his SPO interview, Bislam Zarapi was the one general staff member who did not form part of that group of trusted persons. He was the only outsider. The prosecution brief addresses in detail the various positions and directorates. I will focus today on the deputy commander, general inspector, information, political, intelligence, and police. From mid-November 1998, when he assumed the role, Deputy Commander Krasniqi exercised the full authority of the absent General Commander. While the Krasniqi defense attempts to invert the KLA hierarchy, the evidence clearly establishes that the Chief of Staff ranks below the Commander and Deputy Commanders. Other orders, reports, regulations, and testimony confirm this. The Krasniqi defense selectively cites Naim Moloku's testimony to support its submissions. Moloku clearly testified at transcript page 25749 that Deputy Commander Krasniqi was senior to the Chief of Staff, Zarapi, and exercised the absent General Commander's authority. Krasniqi issued orders Zarapi did not have the authority to issue. Turning to Recep Slimi's roles in the general staff, by at least June 1998, he was head of the operational directorate, and by mid-July 1998, general inspector. The Slimi defense disputes the precise date on which he formally assumed the position of general inspector. It notes that Salimi himself previously indicated he was in the position by August or September, but was unsure. While the evidence clearly establishes that Salimi had this position by mid-July 1998, his role, authority, and activities remained largely the same before and after his formal appointment. As General Inspector, Salimi operated at the level of the General Commander. His function was operational, supervisory, and disciplinary. Salimi himself, including in his 2004 IC2I statement and his 2019 SPO interview, explained that he was in constant contact with zone commanders and participated in the formation and organization of the zones. He confirmed that he personally signed appointments of several, which witnesses have testified to. Some such appointment orders have also been admitted. As General Inspector, consistent with his previous roles in the KLA, Salimi's primary responsibility was to inspect subordinate units on the ground. As set out in various parts of the prosecution brief, Salimi visited brigades, intelligence units, and military police to assess combat readiness, morale, organization, and command. He disseminated and issued general staff orders, and he confirmed whether these orders were being understood and implemented. Thaçi, Vaseli, Kresnici, and other general staff members performed similar functions on the ground, but Salimi did so most frequently and most extensively. Salimi's inspection role is consistent with internal general staff documents. One such document, seized from Recep Salimi, is 3D27, which sets out the concept of inspection. It explains that inspections were designed to supervise combat readiness, morale, and command, and to reinforce the strategic aims of the general staff. On the last page, it provides for the identification of weaknesses and their immediate removal by directives. Salimi conveyed the information he collected during his inspections to the general staff. He reported at its meetings and submitted written inspection reports. One such report, P2924 from January 1999, summarizes his inspections in the Nirodim and Pashtuk zones and of a general staff special unit. Salimi's authority is further illustrated by his appointment as chair of a general staff commission tasked with defining the boundaries of operational zones. Within days of its formation, the commission submitted a written report, which is Exhibit P1108, signed by Salimi, explaining how the boundaries between the Nirodim and Pashtuk zones were determined based on the general staff's strategic platform and inspections on the ground. The defense tries to downplay the importance of this commission and Salimi's role in it. However, that the general staff collectively decided it should be Salimi to resolve such issues between zones is indeed indicative of his role and authority on the ground and the importance of the matter. The same applies to the selection of Salimi and the other accused for the Personnel Council. It was responsible for analyzing and making recommendations on command appointments at the general staff and lower levels. This council is addressed at paragraphs 178 to 179 of the prosecution brief. Taken together, the evidence shows that Recep Salimi moved continuously between the general staff and the operational zones while the charged crimes were ongoing there. He disseminated and issued orders on behalf of the general staff, ensuring that policies and orders were implemented, and that information about events on the ground reached the general staff. Next, the Information and Political Directorates. Thaçi, Vaseli, and Kresnici, in addition to their other responsibilities on the general staff, exercise continuous political authority. Political and military functions within the KLA were deliberately and necessarily intertwined. The Information Directorate was under Hashim Thaçi until mid-November 1998. It issued political declarations and other public statements, controlled access to the media, and required KLA members, including operational zone commanders, to obtain authorization before speaking publicly. These were important tools used to shape public perception, communicate policy, target opponents, and enforce discipline. Exhibit P879, a general staff order from early July 1998, required commanders at all levels to seek the Information Directorate's authorization before giving interviews. On the screen now is an interview with Drenica Zone Commander and named JCE member Suleiman Salimi on 13 August 1998. He begins the interview by confirming he had authorization from the KLA General Staff Information Directorate. By at least June 1998, Thaçi was also head of the political directorate, which included Kadri Veseli and Jakub Krasniqi, the latter also being the KLA spokesperson. Contrary to the defense submissions, the political directorate existed and functioned with Thaçi at its head and with Kadri Veseli and Krasniqi as members well before mid-November 1998. That conclusion is supported by multiple independent sources, including as set out in the prosecution's final brief at paragraph 224. In both P790, an unmixed statement from 2003, and P787, an SPRK statement from 2011, Veseli confirmed his role in the political directorate. On page 2 of P787, which Mr. Tiger has already shown, Veseli states, quote, "I was a member of the KLA main HQ since the beginning. More precisely, I was as well a member of the political directorate. For some years, I lived in Switzerland, where I worked closely with Hashim Thaçi for a long time," unquote. Other evidence also undermines the defense positions. These include a 2006 media interview with Recep Salimi and his 2019 SPO interview, both confirming Thaçi as the directorate's head by June 1998. On your screen now, there's Thaçi's official biography from the Kosovo government website. It states that he was head of the political directorate since 1997. Further supporting the directorate's functioning, a record of meetings on 16 and 26 June 1998 between representatives authorized by the political directorate and internationals was seized from Jakub Krasniqi. That's P3734, and on page 7 it states that the political directorate leads the struggle and deals with its political aspect. From at least July 1998, Thaçi and Veseli were carrying out political functions and meeting international representatives and other Kosovo armed and political groups on the ground. In early August 1998, the General Staff Political Directorate issued a political declaration, Exhibit 1D50, identifying its political representatives, while at the same time threatening those allegedly engaged in a special war with a merciless blow. Further, before the 12 and 13 November meeting, when the defense claims Thaçi was first appointed, he gave his first public statement as head of the political directorate in late October. The evidence on that is cited in paragraph 55 of the prosecution brief. The Thaçi defense claims that as late as 10 November, Thaçi was introduced only as a political representative during a meeting with Frederick Abrahams. However, Abrahams was unequivocal, quote, "My testimony is that he introduced himself as head of the political directorate," unquote. That's at transcript page 7602. Following the mid-November 1998 meetings, Thaçi retained leadership of the political directorate. As seen in the report on your screen, zone commanders look to the political directorate for guidance on agitation, propaganda, morale building, and political preventive measures to stop divisive and traitorous elements. The Thaçi defense makes the bewildering claim in paragraph 307 of its brief that the SPO has failed to prove that this report refers to Thaçi and not Adam Damaci. First, it refers to the General Staff Directorate, headed by Thaçi, not Damaci. Further, the defense's repeated attempts to inflate Adam Damaci's authority and position are unsupported. Damaci was entrusted with a limited role in the creation of Kosovo institutions, but he was not a member of the General Staff, and he was subordinated to Thaçi. In addition to his political role, Kadri Veseli was also head of the Intelligence Directorate. Initially, intelligence was a shared responsibility among general staff members. By May 1998, general staff communiques, such as P155, reported on the activities of the intelligence service. On your screen is Vaseli's explanation that by June 1998, the general staff decided to establish the Intelligence Directorate, known as G2. In its brief at paragraphs 295 and 296, the Vaseli defense refers to this account, but dismisses evidence of directorates before November 1998 as aspirations and nominal titles. The facts demonstrate otherwise. After the General Staff's decision to establish the Intelligence Directorate, Vaseli was present on the ground across multiple zones when intelligence units were being established and were operating. They formed part of the structures that the accused and General Staff members were coordinating, inspecting, organizing, and overseeing. Mr. Poch has already discussed Sabagetsi, who led an intelligence unit active in the Drnica zone and reported directly to Kadri Vaseli and the General Staff. In the Dukagin zone, the head of intelligence, Fatou Mehmetai, was appointed by late June 1998. As set out in our brief, the Dukagin intelligence chief and his sector targeted charged victims detained at Yablonitsa and other opponents during the indictment period. Kadri Vaseli, as well as Hashim Thaçi, Recep Salimi, Jakub Krasniqi, and Lahi Brahimai, were present on the ground in the Dukagin zone, meeting with its command in June and July 1998. They were also aware of Mehmetai's role. This is shown by, among others, exhibits 2D26 and P13191. In early August 1998, mirroring Vaseli's own dual intelligence and political roles, the Political Directorate publicly announced Mehmetai as a political representative, alongside Thaçi and Krasniqi. That's exhibit 1D50. Less than a month later, the General Staff, in an order signed by Recep Salimi, appointed Mehmetai head of public information in the Dukagin zone. The appointment is exhibit P1947. Like in Drnica and Dukagin, intelligence personnel were involved in targeting opponents and charged detention sites across zones and in northern Albania. That pattern is entirely consistent with regulations such as Exhibit P890, which set out intelligence duties. Those duties included identifying individuals important to the enemy, domestically and abroad, and enforcement powers such as kidnapping or killing such individuals. The involvement of the intelligence sector is also consistent with the document on your screen now. The version on your screen was found on Krasniqi's computer, and another version was seized in hard copy. The job description at the third bullet point from the bottom sets out intelligence responsibilities, including the processing of material collected from civilian prisoners and captives. Within the zones, intelligence reports were produced regularly. Zone intelligence chiefs compiled and transmitted those reports to both the zone commander and the general staff. The head of intelligence in the Pashtuk zone, for example, testified that he printed 3 copies of his reports, one specifically for transmission to the general staff. While the Vaseli defense brief focuses on his absences from Kosovo, paragraph 266 of the prosecution brief already addresses that point. During such absences in early 1999, others, including as installed by Vaseli, exercised intelligence functions at the general staff level. He also had communications means at his disposal, enabling him to coordinate with those present in Kosovo when he was absent, and did so. Veseli has claimed that his appointment to SHIC, publicly announced on 2 April 1999, ended his role within the General Staff. However, the evidence demonstrates continuity as set out in paragraph 268 of the prosecution brief. Veseli himself later described the Kosovo Intelligence Service as having a continuity of mission from the KLA through the provisional government and after. He did this in an interview, Exhibit P1859, and he also did it in a public statement announcing the closure of SHIC in 2008, Exhibit P4213. I'll play an excerpt from that now. It has English and Albanian subtitles and does not require interpretation.
Shërbimi informativ I Kosovës ka nisur punën e vet që nga fillim vitet e 90-ta me krijimin e ushtrisë qlirimtare të Kosovës dhe me vonë pjesë e qeverisë së përkohshme të Kosovës me kryeministër Hashim Thaçi. Në të gjitha periudhat e veprimtarisë së vet, Shërbimi informativ I Kosovës ka punuar me mision legjitim për çlirimin e vendit dhe krijimin e shtetit të Kosovës. Pas çlirimit të vendit, në vitin 1999, Shërbimi informativ I Kosovës ka ruajtur vazhdimsinë e misionit të vet.
By June 1999, SHIC comprised approximately 30 members, including as directly drawn from former zone intelligence. For example, despite his previous and repeated direct involvement in crimes when he was head of intelligence in the LAP zone, Latif Gashi was the SHIC general director. Taken together, the evidence demonstrates a continuous, structured intelligence system under Veseli's authority. Turning to the police, which cooperated closely with the intelligence services in the charged crimes. From late spring 1998, like intelligence, military police were operational in areas where the accused and general staff members were present and exercising their authority. They also form part of the structures in the zones that the accused and the general staff members were coordinating, inspecting, organizing, and overseeing. Consistent with the duties outlined in the provisional regulations, which granted the police extensive powers, military police on the ground manned checkpoints, stopped civilians, recorded personal details, arrested, detained, mistreated, and killed opponents, as detailed throughout the prosecution brief. By at least November 1998, the General Staff had a formally appointed JCE member, Fatmir Limai, as head of the Military Police Directorate. As set out in paragraphs 283 to 285 of the prosecution brief, Zone Police reported to the Directorate, which oversaw appointments, logistics, training, inspections, and General Staff detention centers. On 2 April 1999, Recep Slimi's appointment as Minister of Public Order in the Provisional Government was announced. By at least June 1999, he had traded in his camouflage for a black uniform. The next two slides are screenshots from P4228, taken a day after the Kumanova Agreement was signed on 9 June 1999. On the first, you can see Recep Slimi at the right end of the table, in black using a radio. And he's in the same position on the second screenshot. Other general staff members and provisional government officials, including Hashim Thaçi, are in camouflage. Four days later, on 14 June 1999, Kosovo Press and Radio Free Kosovo published the Ministry of Public Order's first communique, which states it was signed by Salimi, the communique declares that the return of the population would be under the direction of the KLA military police, described as the nucleus of the future police force, and refers also to the mandate of the public order forces. The communique is P515 ET.69 and P814 ET.35. The public order forces that emerged by June 1999 consisted largely of former military police personnel. Documents seized from Salimi confirmed the structure and the functioning of the Ministry of Public Order, including when considered together with the activities of the police on the ground in summer 1999. As set out in paragraphs 301 to 302 of the prosecution brief, such seized documents include organizational charts, personnel records, reports including from police commanders in the zones, identification cards, and registration forms from KLA members across operational zones. These records concern multiple individuals involved in charged crimes. I've already discussed SHIC and the Ministry of Public Order, which were continuations of the KLA intelligence and police. Other accused and general staff members were also assigned overlapping roles in the provisional government. The slide on your screen shows the composition of the provisional government in spring and summer 1999. The dark blue boxes are the general staff members appointed to positions in the provisional government. The same group of trusted persons again make up the decisive majority, with the ability to control and exercise authority through the provisional government. The yellow frames indicate the accused, the black frames indicate named JC members. One of the light blue boxes includes the deputy post reserved for the LDK, which remained vacant. Ms. Lawson has already explained the reasons. There are also the 4 positions held by LBD members in light blue. The LBD supported and was aligned with the KLA. To the extent the Krasniqi defense suggests that he was appointed as Minister of Reconstruction by the LBD, there is no evidence confirming that, and it doesn't matter. Even if the KLA-aligned LBD had proposed him for this position, it does not change the fact that Krasniqi was also provisional government spokesperson, which was not proposed by the LBD, nor does it impact on his long-standing membership of the General Staff and KLA. The provisional government was formed after the Rambouillet negotiations. In late February 1999, the General Staff confirmed Thaçi as Prime Minister and Suleiman Salimi as General Commander. Suleiman Salimi's appointment and subsequent reassignment constitute a concrete and early example of the accused and other JCE members using the provisional government as a parallel vehicle to exercise their authority. They would continue to use it for this purpose and to execute their common plan. Suleiman Salimi's formal appointment followed previous meetings of general staff members and the zone commanders while the Rambouillet delegation was abroad. However, contrary to defense submissions, the election of Suleiman Salimi as general commander in February 1999 was not a coup. Suleiman Salimi himself acknowledged this during testimony. This event was not, as the Thaçi defense contends, an emblematic example of zone commander's authority over the general staff. Of course, that is not to say that the February 1999 meetings, where the change of command was debated, were not contentious. But contention alone in no way supports the defense's submissions. Conversely, the true authority of the general staff is demonstrated by the surrounding circumstances and the actions it took. First, the general staff only confirmed the change of command upon the return of the members of the Rambouillet delegation, The evidence supporting this is set out in paragraph 148 of the prosecution brief. Perhaps most telling, the zone commanders ultimately agreed with the Rambouillet delegation, including the accused, that the resulting agreement should be signed. Thaçi did not engage in a convincing, cajoling, and supplicating tour to achieve this result, as the defense suggests, without evidentiary support. Rather, he and other general staff members, including the other accused, consulted with their highest-ranking military subordinates on the ground to ensure sufficient buy-in for an agreement that would require their commitment to fulfill. Exhibit P227 on the screen records the positive opinions held in the Army regarding the Rambouillet agreement. It followed general staff consultation with the zone commanders and notes that the general staff will make the final decision. Notably, while it is signed by all accused and other general staff members, it is not signed by Suleiman Salimi. On 2 April 1999, Thaçi publicly announced the provisional government ministers. Among them was Azam Sula, the now former general commander, in the position of Minister of Defense. Later, in April 1999, Agim Cheku, who was a close associate of Thaçi and Veseli, became the General Staff Chief of Staff. Suleiman Salimi was appointed the National Guard Commander. In this position, he reported to Agim Cheku and was once again subordinate to Azam Sula, now as Minister of Defense. This reporting relationship is evidenced by written reports from Cheku to Sula, as cited in paragraphs 129 and 165 of the prosecution brief, and the testimony of Suleiman Salimi himself. That's transcript page 25239. It is this series of events, properly viewed in context, that illustrates the true state of play. The General Staff and Provisional Government, led by Hashim Thaçi, maintained control throughout. The Thaçi defense wrongly claims that there is no evidence that Provisional Government ministers Agim Cheku, as General Staff Chief of Staff, reported to Hashim Thaçi as Prime Minister. While the General Staff and Provisional Government continued to reach decisions by a process of collective deliberation, Thaçi had the authority to implement and enforce such decisions, including through his appointments and his decrees, and reporting lines went to him. For example, Thaçi appointed Cheku following consultation with the General Staff, and as demonstrated by the appointment decree P112, supported by the proposal of the Ministry of Defense. This was confirmed by Bislam Zarapi, who discussed this personal change directly with Thaçi and Recep Salimi. Suleiman Salimi, at transcript pages 25240 to 1, also agreed with the evidence of Zarapi and Recep Salimi on this point. In a 2000 interview, Exhibit P1745, Suleiman Salimi stated that Hashim Thaçi set up the provisional government and, as Prime Minister, officially took the duties of KLA, quote, commanding general, unquote. Krasniqi, in his book, The Big Turn, likewise confirmed that the General Staff gave powers to the Prime Minister to form the provisional government. In addition to appointing Cheku, it was Thaçi who appointed Sula as Minister of Defense, just as he had appointed other ministers, including Salimi and Veseli. Both Salimi and Veseli confirmed that Veseli, as head of Shik, reported to Thaçi. That's at paragraphs 266 and 514 of the brief. In spring 1999, Cheku reported to Azam Sula as Minister of Defense, who in turn reported to Thaçi as Prime Minister. Further, when issuing decrees, for example, Decree 8399 on your screen, Thaçi tasked provisional government ministers and the General Staff. this decree concerned the formation of the National Guard. And in it, Thaçi tasked the General Staff and Ministry of Defense with shared responsibility for the decree's implementation. The next slide shows that Prime Minister Hashim Thaçi, at proposal of the General Staff, issued a decision in May 1999 restructuring the KLA with the Prime Minister's signature block and the General Staff stamp. In doing so, Thaçi tasked the Ministry of Defense with drafting the formation charts for every KLA unit, detachment, and structure. In the words of Agim Cheku, recorded in Exhibit P4228, shortly after the Kumanovo Agreement was signed, any decision of the Kosovo Provisional Government would be considered an order for the Kosovo Liberation Army. Indeed, it was Thaçi, not Cheku, who signed the undertaking in which the KLA agreed to demilitarize. Thaçi signed that document as KLA Commander-in-Chief. John Duncan, the very diplomat who drafted the undertaking, confirmed that the Commander-in-Chief title was only added after Thaçi became the nominated signatory. In another example, in August 1999, Thaçi sent a letter to the head of UNMIK, Bernard Kouchner, requesting that certain individuals, including Minister of Defense Azam Sula, be allowed to legally carry arms. That's P880. Thaçi signed this letter as General Commander of the KLA. There can be no doubt about Thaçi's position and authority as Prime Minister, which he obtained and exercised through the collective decision-making of the General Staff and Provisional Government. As Serbian forces withdrew in June 1999, the KLA and Provisional Government pursued all classic avenues of power. KLA and Provisional Government members seized key state infrastructure and public institutions. They installed mayors, they held meetings, they issued decrees and decisions. KLA members continued to target opponents across operational zones, including as charged. Having addressed the General Staff and Provisional Government, I'll now turn to the zones established and operating under their authority. Drenica, Dukajin, Pastrik, Shala, Lap, and Nerodim were formally established and their zone commanders appointed and confirmed by the General Staff over the course of spring and summer 1998. Karadak was established later, with its commander appointed in late 1998. Throughout the indictment period, the KLA also maintained a series of bases in northern Albania. At charged crime sites and in other locations in the zones and northern Albania, KLA members, including police, intelligence, and special units, targeted, detained, mistreated, tortured, killed, and disappeared opponents. The evidence demonstrates that the zones and bases in northern Albania complied with General Staff orders and instructions and respected General Staff authority. This is detailed in the prosecution brief, and I will discuss a few more examples today. The defense wrongly claims that no superior staff issued orders to the Dukajin zone. The evidence demonstrates that the zone command respected the authority of the General Staff and complied with its orders. The way this worked in practice is illustrated by a series of complementary contemporaneous records from early July 1998, soon after the zone had been established. They were obtained and seized from different sources. On your screen is a 1 July 1998 decision of the General Staff forbidding communication with journalists. It further provides that the General Staff Information Directorate decides on informing the public, and that only the KLA spokesman has the right to make known the KLA's positions. The next slide contains the minutes of a work meeting of the Ducagene Command held that same day, 1 July. This meeting was attended by Recep Salimi using his alias Agron, which is the alias he used in the Ducagene zone. He is recorded in the meeting minutes as saying that the spokesman conveys the views of the General Staff Headquarters. That's consistent with the 1 July decision we just looked at. Then, there is a 2 July 1998 notice sent by Zone Commander Haradnai to the General Staff. It informs the General Staff that the Ducagene Zone staff had, quote, implemented to the letter the order dated 1 July 1998 regarding communication with the media and journalists, unquote. And finally, there is the warning Haradnai sent to subordinate headquarters in the Ducagene Zone concerning the 1 July 1998 General Staff decision. Overall, this chain of evidence demonstrates swift and effective implementation of and respect for General Staff orders. It also reinforces the need to consider the evidence holistically. Not only did the General Staff issue orders that were complied with, the accused and General Staff also personally and directly enforced their authority. For example, when the General Staff, represented by Thaçi, Salimi, Brahimai, and other General Staff members, removed the popularly elected Tahir Zamai and reinstalled Haradnai as Zone Commander in early September 1998. Zone commands also reported to the General Staff, including on specific matters that the General Staff ordered information on. On your screen is a General Staff order for zone commanders to report on specific questions, problems, and proposals. Topics specified range from leadership to personnel issues, coordination with other zones and civilian bodies, and requests for the General Staff. The next slide includes excerpts from the LAP zone's response, which correspond to the topics on which the General Staff requested reports. Topics covered include the military police, the civil defense, cooperation with other zones, requests for ammunition and weapons, and proposals for zone and brigade command appointments. This information provided by the zones was then conveyed in a report to Deputy Commander Krasniqi. It included information corresponding to the report by the LAP zone, including on the LAP zone's appointment proposals, territorial and civilian defense, military police, and cooperation between the zones. The evidence cited in, among others, paragraph 363 of the prosecution final brief demonstrates that in addition to complying with reporting obligations, the LAP Zone Command implemented General Staff orders on organization, operations, and detention sites. This was confirmed by Zone Commander Mustafa and his Chief of Staff in court. The defense claims that the so-called Podiyeva line incident illustrates the resistance of zone commanders to General Staff instructions. However, this was an isolated incident. Rustam Mustafa's refusal to follow Zarapi's request on this matter is not capable of displacing the corroborated and complementary evidence demonstrating General Staff authority in the LAP zone. It should also be considered in the context of previous General Staff decisions. On 19 November 1998, the General Staff communicated that the Serbian police should withdraw from their positions, including in LAP, and threatened that if they did not withdraw, KLA patrols would strike. The General Staff position, reflected in Exhibit P668, was disseminated and discussed in the zones. This is demonstrated by, for example, P3190, page U002-0275. Since that was the General Staff's instruction in late November 1998, it is not surprising that in early December 1998, Mustafa's forces moved into vacated positions and challenged Serbian police. The General Staff also provided instructions directly to subordinate units in the zones that were involved in the commission of charged crimes. For example, in the Drnica zone, Military Police Commander Said Yashari reported to both the zone commander and the General Staff. Defense claims to the contrary ignore the record. As Mr. Tiger has already discussed, already in May 1998, Said Yashari had declared that the military police would follow orders given by the General Staff. Further, as discussed at paragraph 370 of the Vaseli brief, Soliman Salimi testified that Limay issued an order around November 1998 mandating military police to report to him in, quote, a hierarchical manner. Other evidence also confirms this reporting line. On your screen are Recep Salimi's handwritten notes of an organizational meeting in early December 1998 between military police director Limay and military police commanders in the Drnica zone. Later, in early February 1999, Limay ordered the Drnica Zone Command to send a list of candidates for the military police, to be accompanied by photographs for each candidate and necessary details. The purpose was further organization of KLA military police units. About 2 weeks later, Said Yashari provided such information on all zone and brigade police members, including photographs. This is clearly in response to Limay's order, contrary to Salimi's submission at paragraph 245 of his brief. The Military Police Directorate also received requests from and provided instruction to police in other zones. On your screen, there's a request from the Nirodim Zone Military Police Commander, Isaac Musliu, requesting military police regulations, clarification, and logistics. On 18 December, as seen on the next slide, the head of the Military Police Directorate provided clarification concerning regulations, hierarchy, and arrest powers. Excerpts of Salimi's notes on the next slide of an inspection in the Nirodimi zone in early July 1999. At the bottom, there's another excerpt. And at number 10, they record past complications concerning arrest powers, noting that the issue had been addressed after the relevant police regulations were received. Finally, it was not only the Military Police Directorate that could issue orders to the military police on the ground. For example, in December 1998, the General Staff, through a series of orders issued by Jakub Krasniqi, the Finance Directorate, the Civilian Administration Directorate, required contributions to the Homeland Calling Fund from workers temporarily employed abroad, and ordered the police to collect such contributions. The orders are exhibits P3681, P3684, and P3686. A contemporaneous KLA notebook entry from early January records this order. And on the next slide, which is not for public broadcast, we see that the military police enforced the order. The Brigade 121 military police commander even reported 2 military police members to the General Staff for failing to fully and properly implement the decision. He referred to the functioning of the LDK in a particular village as the main reason for obstacles in their work. The Krasniqi defense submissions about this series of orders miss the point, that is that general staff orders, including as issued by Krasniqi, were disseminated and were complied with, including by members of the Brigade 121 military police. This demonstrates authority over KLA members involved in charged crimes. The general staff, provisional government, and zone structures I have discussed are addressed in much more detail in the prosecution brief. The accused had authority over these structures and used them to execute their common criminal plan. Thank you, Your Honor. Tomorrow morning, I will hand over to my colleague, Matt Howling, who will discuss the remaining elements of individual criminal responsibility.
Thank you. We will be adjourned until 9 a.m. tomorrow. Thank you all for your attendance. We'll see you tomorrow. I might ask before you leave, what's the times? You've got about at least 2.5 hours left.
Yes, I expect to be slightly under 2 hours, and then the specialist prosecutor will have concluding remarks. So we'll comfortably finish within
Okay,
the
we
time.
owe you a few minutes from this morning too, because we used some of your time then. So there should be adequate time. Thank you, everybody. We'll see you tomorrow.
All rise.